định có thể viện dẫn những cái quan điểm của VF và của hội đồng trọng tài, và từ đó có thể là không hủy các phán quyết trọng tài. Và tương tự như vậy thì trong lĩnh vực thi hành cái phán quyết trọng tài á, thì thực tế là có những cái phán quyết trọng tài tôi biết được rằng từ nước ngoài, từ ICC thì say ắt đem về Việt Nam, mà lỡ có một cái lỗi gì đó, ví dụ như là liên quan đến cái tiền tệ đi, có thể là sai cái đơn vị tiền tệ, dẫn đến là cục thi hành án dân sự thành phố Hồ Chí Minh không thể thi hành được cái phán quyết trọng tài nước ngoài đó vì lý do đã được công nhận nhưng mà sai đơn vị tiền tệ. Thì trong trường hợp đó thì rất là khó mà cái giải thích sửa đổi bổ sung cái phán quyết trọng tài nước ngoài. Tuy nhiên đối với VF thì cái việc mà các cơ quan thi hành án dân sự thì phối hợp với VF rất là tốt, và cái hội đồng trọng tài trong cái việc giải thích và sửa chữa cái phán quyết trọng tài rất là nhanh, và điều đó sẽ giúp cho cái việc thực thi cái phán quyết trọng tài nó tốt hơn. Thì tiếp theo nữa thì nó liên quan đến những cái vấn đề tiếp theo là liên quan đến một số cái vấn đề liên quan đến thời gian giải quyết vụ tranh chấp trung bình của VF. Thì chúng tôi là thời gian giải quyết theo thống kê của chúng tôi là khoảng 7,4 tháng, và điều đó thì cũng là khá nhanh so với một số tổ chức trọng tài trong nước và khu vực. Và liên quan đến cái chi phí trọng tài thì chúng tôi cũng được đánh giá là một cái tổ chức trọng tài có chi phí trọng tài cạnh tranh so với một số cái tổ chức trọng tài quốc tế khác. Một điều mà chúng tôi muốn chia sẻ thêm là liên quan đến chi phí luật sư. Thì đối với VF thì chúng tôi thứ nhất là vai trò luật sư quốc tế thì tham gia VF thì nó không khác một cái tổ chức trọng tài quốc tế khác. Riêng về phí luật sư thì chúng tôi là không tính phí trọng tài của phí luật sư, và trong những cái vụ kiện liên quan đến phí luật sư tại VF thì 85% các vụ tranh chấp mà một bên thắng kiện thì được bồi hoàn cái chi phí luật sư, và trong đó thì có 15% là cái chi phí luật sư không được chấp nhận vì lý do là không đầy đủ chứng cứ và không thuyết phục được hội đồng trọng tài chấp thuận. Trong đó thì phải nói là có những cái tranh chấp liên quan phí luật sư rất là lớn, thì đi lên con số là khoảng là 109 tỷ Việt Nam đồng, thì tương đương với một con số rất lớn là 4,5 triệu US đô la, và cho những cái tranh chấp rất là lớn là 236 triệu US đô la. Và cuối cùng thì để có thể là chọn một cái tổ chức trọng tài giải quyết tranh chấp thì theo cái quan điểm của các bên sử dụng dịch vụ trọng tài thì nó phải là một cái tổ chức trọng tài mang tính chất là ổn định, và cái điều khoản trọng tài phải tương thích và có thể giải quyết được nhiều cái vấn đề thực tiễn tố tụng trọng tài phát sinh, và đội ngũ ban thư ký thì thật sự phải chuyên nghiệp, và chi phí trọng tài nó phải là hợp lý. Và hơn nữa thì hơn tất cả những cái vấn đề là trọng tài viên là người quyết định nên cái chất lượng của vụ giải quyết tranh chấp. Thì đối với VF thì trọng tài viên thì chúng tôi thì rất là đa dạng, và đến từ rất nhiều quốc gia, thì có 36 trọng tài viên nước ngoài. Bên cạnh đó thì các bên có thể lựa chọn những cái trọng tài viên ngoài danh sách. Và như vậy thì xin nói thêm là VMC thì cũng tương tự như vậy, thì cũng rất là nhiều cái hòa giải viên quốc tế và trong nước tham gia với VF. Thì cuối cùng thì một cái thông điệp thì không mới nhưng mà chưa bao giờ cũ, thì đó là nếu mà giải quyết tranh chấp trọng tài tại Việt Nam thì highly recommend là chọn VF. Xin cảm ơn.
Xin cảm ơn ông Cao Việt Bắc. Tôi thấy là ông cũng dừng vào cái lúc mà timekeeper thì cái bảng lên là time over, cho nên là thực ra thì ông cũng đã dùng hết thời gian. Thì chúng ta vừa nghe ông Châu Việt Bắc trình bày một cái tổ chức trọng tài của Việt Nam, và trong các cái tranh chấp về dự án năng lượng theo luật pháp Việt Nam thì chúng ta biết là có những cái cấp độ khác nhau. Có những cái trường hợp như bà Quỳnh đã trình bày là bắt buộc phải chọn trọng tài Việt Nam, khi nào thì bắt buộc như vậy. Rồi cũng có nhiều trường hợp thì được phép chọn trọng tài nước ngoài, trọng tài quốc tế. Thì khi nào như vậy thì nó thể hiện ở không chỉ trong luật pháp Việt Nam mà trong các cái hiệp ước. Thì như lúc nãy chúng ta vừa nói là Việt Nam đã ký 15 cái hiệp định thương mại song phương. Nhưng mà khi nói đến cái hiệp định thương mại thì chúng ta chưa nói là ví dụ hiệp định thương mại song phương, hiệp định thương mại đa phương với EU, EVFTA, thì cái phần bảo hộ đầu tư đó, tức là Investment Protection Agreement đó, thì nó tách ra thành một cái hiệp định riêng. Thứ hai là ví dụ chúng ta có CPTPP, tức là Comprehensive Progressive Pan-Pacific Partnership thì cho phép thỏa thuận trọng tài nước ngoài. Nhưng mà nếu mà chúng ta nói đến cái EV Investment Protection Agreement đó, thì nó lại có một cái permanent court để giải quyết tranh chấp. Thì nói chung khi nào được chọn trọng tài và chọn trọng tài nào thì chúng ta phải tham khảo các cái hiệp định thương mại và các cái hiệp định đầu tư song phương, như là ông Sơn trình bày là có đến hơn 40 cái hiệp định đầu tư song phương mà Việt Nam đã ký với các quốc gia. Thì chúng ta vừa nói đến trọng tài Việt Nam, nếu mà tôi cũng thật là khách quan thì tôi cũng công bằng, tôi phải nói thêm là ở Việt Nam thì không chỉ có VIC. Theo luật trọng tài thương mại Việt Nam thì cái việc thành lập các tổ chức trọng tài là có những cái điều kiện nhất định, và hiện nay thì cũng có nhiều tổ chức trọng tài phi chính phủ đó đã được thành lập ở Việt Nam. Tuy nhiên thì tất nhiên là VIC là tổ chức lâu đời nhất và cũng là tổ chức lớn nhất hiện nay. Thì bây giờ thì chúng ta đi đến cái tổ chức trọng tài nước ngoài, đó là PCA. Ông Neil sẽ trình bày về cái sự hiện diện của PCA ở Việt Nam, và chắc là ông cho biết thêm là Việt Nam có phải là thành viên của PCA không, vì sao mà có cái sự có mặt ở đây, và nếu tôi không lầm thì nó liên quan đến cái quy định của cái CPTPP. Cái hiệp định này cho phép các bên được thỏa thuận trọng tài các tổ chức trọng tài nước ngoài, trong đó có PCA. Thì xin mời ông Neil trình bày.
Good afternoon, everyone. First of all, on behalf of the Permanent Court of Arbitration, otherwise known as the PCA, I would like to thank Mr. Vu Tien Loc and Mr. Vu An Duong of the Vietnam International Arbitration Center, as well as Ms. Huyen of the Vietnam Business Lawyers Club for inviting the PCA to speak in today's event. By way of background, the PCA is an intergovernmental organization established by treaty to facilitate the peaceful resolution of international disputes. Among the disputes that the PCA has administered would include interstate disputes, for example, the South China Sea dispute, investor-state disputes, and also contract-based arbitrations. Also, Vietnam became a party to the PCA in 2011 when it acceded to one of the founding conventions of the PCA. This was followed in June 2014 when the Vietnam and the PCA concluded a host country agreement, and then by an implementing protocol in October 2021 for the establishment of a PCA office in Vietnam. In November 2022, that was last year, we formally opened the PCA Hanoi office. Our office is located in Hanoi along Cham Phu Street. So if any one of you is interested to know more about the PCA, please feel free to drop by our office. My presentation will be very quick, and there's a lot of issues that can be discussed about energy disputes. What I would like to discuss in today's session is the right to regulate in investor-state energy disputes. As you may have heard from my fellow panelists from the Ministry of Planning and Investment and Ministry of Investment and Trade, there would be times when countries would be attracting investors to come to their countries and make an investment. So in the course of those negotiations, sometimes countries will enter into an investment agreement. So once both states would offer incentives so that when an investor from the other state comes to the host state, these states will be offering, for example, tax incentives and other packages. So in the course of international investment law, there have been disputes. Sometimes an investor will file a claim against the host state for several reasons. It could be because the investment was expropriated allegedly without reason, or for failure to provide a stable framework. So in those instances, you can see that the investor files a claim, in which case the question arises, what will be the defense of the host state? In the PCA's experience, as well as in other institutions, there has been a trend where the host state will invoke its right to regulate. In other words, the state would say, although I offered you these incentives, it does not mean that you can do whatever you want. That's basically the context of the right to regulate. So my presentation is divided into 3 parts. The first will give you an overview of the PCA's docket, where the right to regulate has been invoked in energy disputes. The second part will show you an illustrative example of a treaty provision that has been invoked in these cases. And the last will be 2 sample cases where there has been this issue of the right to regulate. Proceeding to the next slide. Okay. This is the outline of my presentation, as I have introduced a while ago. This one shows a graph of the number of cases administered by the PCA, specifically with respect to energy, and which involved the right to regulate, meaning the state interposed it as a defense. As you can see, it started in 2008. And it's, of course, because of the limited sample, we cannot establish a trend that this will happen all the time. But based on the cases that we have handled, the right to regulate has been invoked by the host state in these years. There was a peak sometime in 2014 when at least 6 PCA cases involving energy, involving an energy dispute, where the right to regulate has been invoked by the host state. Not all of those cases, of course, would be public. So my discussion would be limited to publicly available cases. And I would like to choose the North American Free Trade Agreement, or NAFTA, particularly Article 1105, paragraph 1. There are 2 situations where the right to regulate is usually invoked. The first is with respect to the prohibition of unlawful expropriation, and the second is instances involving fair and equitable treatment. Article 1105 of NAFTA provides or contemplates fair and equitable treatment. There are 2 cases, publicly available cases administered by the PCA, where this has been invoked, which now leads me to the next part of my presentation. The first is Mesa Power Group versus the Government of Canada, because as in the case of Vietnam, Canada also embarked on utilizing and promoting the use of renewable energy. In the course of its program, there was a prospective US investor which tried to get contracts with the Canadian government. However, during the application process, the claimant was not able to obtain a contract. What the claimant did was it instituted proceedings against Canada on the basis that there was a violation of the provision that I just showed you a while ago, 1105 paragraph 1 of NAFTA. In this case, the tribunal consisted of 3 arbitrators, as shown on the slide. We have Professor Kaufman-Kohler, Judge Charles Brower, and Mr. Toby Landau. What happened in this case, the tribunal dismissed all the claims of the claimant. In this particular case, the tribunal said that international investment law, and in interpreting Article 1105(1) of NAFTA, the tribunal said that there is a high level of deference accorded to states, such that when states undertake certain policy decisions, the tribunal cannot act as an appellate court. that the tribunal cannot second guess the intentions or the objectives, the policy objectives of the host state, which is why, according to the tribunal in this case, there was no violation of Article 11051. The other opposite of this case is Windstream Energy also versus Government of Canada, where in this case, the Government of Canada imposed a moratorium on offshore wind farms. The problem in this case is the claimant already made an investment, and then the government imposed this moratorium. And because of the imposition of this moratorium, the investor said that it severely suffered losses and was in violation of NAFTA Article 11051. The defense of the government was also, among others, the right to regulate. According to the Government of Canada, it was out of a legitimate policy that it wanted to ensure that the offshore wind farms are based on scientific evidence, meaning it wanted to be careful about this policy in promoting the use of renewable energy. What the tribunal said in this case is, while the state is accorded deference when it comes to legitimate policy objectives, the government, however, according to the tribunal, was not able to provide a stable framework such that during the negotiations, the government should have provided the investor a clear indication as to how the government will be handling this investment. Because according to the tribunal, the right to regulate is not foolproof. Like, it does not completely shield the host state from its obligations under the relevant treaty. And so in this case, the tribunal upheld and granted the claim of the investor, but only with respect to that provision of NAFTA. All other claims of the claimant in this case were dismissed. And so, as I've said, we cannot provide like a clear, a lot of it depends on the text of the treaty, on the text of the agreement. Whether or not the right to regulate by the host state will be appreciated by the tribunal would depend on the text of the treaty and the circumstances of that case. But what I have tried to do in today's presentation is to give you an idea on how the right to regulate can play. It could either be upheld or dismissed by the tribunal, depending on the circumstances. But what is clear is, in energy disputes, there is this possibility that the host state will invoke this right against claims of unlawful expropriation or failure to provide fair and equitable treatment. This ends my presentation, and here's my contact information. If you happen to be in Hanoi, please feel free to visit. Thank you very much.
Thank you, Mr. Neo Nuku, representative of the PCA in Vietnam. Thưa các bạn, theo quy định thì chúng ta sẽ dành một ít thời gian để cho cái phần hỏi và đáp. Thì chúng tôi xin mời quý vị, nếu có câu hỏi thì chúng ta cho biết. Xin mời anh cũng tự giới thiệu luôn và cho câu hỏi.
Xin chào các diễn giả, thì em là Hoàng, đại diện của công ty VSC Lawyer. Thì em có hai câu hỏi đến cho đại diện của Bộ Công Thương ạ. Câu hỏi thứ nhất đấy là hiện nay thì có cái cơ chế về mua bán điện thí điểm DPPA ấy, thì sắp được ban hành, thì em muốn hỏi là cái thẩm quyền ban hành hiện tại á, thì đầu DPPA, cơ chế thí điểm DPPA là sẽ của Quốc hội hay là của Chính phủ? Bởi vì theo cái nghị định mới ấy, thì có vẻ như là Chính phủ là không còn, Thủ tướng Chính phủ không còn quyền ban hành cái này. Đây là câu hỏi thứ nhất. Câu hỏi thứ hai là theo đề án tái cấu trúc mới nhất của Bộ Công Thương thì sẽ có một cái văn bản gọi là luật năng lượng tái tạo. Thì em muốn hỏi là dự kiến thì luật năng lượng tái tạo khoảng bao giờ sẽ ban hành, và có phải là năng lượng tái tạo đấy sẽ thay thế toàn bộ các văn bản liên quan đến điều chỉnh các cái quy định hiện tại của năng lượng tái tạo, ví dụ như là về gió, mặt trời hay là các cái điện năng lượng tái tạo khác, ví dụ như hydro hay là sinh khối hay không? Đây hai câu hỏi của em.
Tôi xin hỏi còn câu hỏi nào cho Bộ Công Thương nữa không ạ? Nếu không thì để tiết kiệm thời gian, chúng tôi xin mời ông Sơn trả lời. Và ông có thể ngồi tại chỗ.
Trả lời hai câu hỏi của anh Hoàng thì tôi xin phép trả lời này. Hiện nay thì cái cơ chế mua bán điện trực tiếp thì Bộ Công Thương đang xây dựng cái thông tư để thực hiện cái cơ chế mua bán điện trực tiếp, và cái này thì báo cáo anh Hoàng là bên chỗ Bộ Công Thương tôi cũng đã soạn thảo từ năm ngoái, và cái việc này thì đang hoàn thiện. Tôi hy vọng là trong vòng khoảng 2 tháng nữa thì cái văn bản này sẽ được ban hành. Cái đấy là cái nhất. Cái thứ hai liên quan đến anh hỏi là Bộ Công Thương có được giao chủ trì xây dựng một cái luật liên quan đến năng lượng tái tạo và để thay thế tất cả các văn bản quy phạm pháp luật khác. Đấy là những cái quyết định hoặc là những quy hoạch của chính phủ hoặc là văn bản của Bộ Công Thương liên quan đến điện gió, điện mặt trời, điện sinh khối hoặc địa điện. Thì cũng báo cáo với anh, thông tin thêm cho anh là Bộ Công Thương là cũng chưa được giao và cũng chưa đề xuất xây dựng một cái luật riêng này, và hiện nay chúng tôi đang làm hồ sơ để trình chính phủ làm một cái luật thay thế cái luật điện lực năm 2004. Ở trong đó có những cái nội dung liên quan đến chỗ việc năng lượng tái tạo và liên quan đến bổ sung cái nội dung liên quan đến phát triển cái công nghiệp năng lượng. Đấy là các cái ví dụ như về tấm pin mặt trời rồi là địa điện. Cả xin hết.
Xin cảm ơn ông Sơn. Xin hỏi quý vị là có quý vị nào có câu hỏi tiếp theo không ạ? Còn nếu quý vị không có câu hỏi nào tiếp theo thì tôi hiểu rằng là các diễn giả đã trình bày rất là tốt, và do đó thì đã hoàn thành rất là tốt cái nhiệm vụ của mình. Và tôi xin cảm ơn các diễn giả và xin cảm ơn quý vị đã lắng nghe. Chúng ta kết thúc cái
Vâng ạ.
phiên tại đây.
Xin cảm ơn các diễn giả của phiên 1. Sau đây thì tôi xin phép được bắt đầu phiên 2 ạ. Do các diễn giả ở phiên 2 thì đều là các diễn giả nước ngoài. Xin phép được trao đổi tiếng Anh. I'd like to invite you to stage the moderator and the speakers of the session 2, legal risks and dispute management in conventional energy projects, insiders' views. I'd like to invite Miss Amanda Lee's partner of King & Wood Malescence, Miss Shamila Nilakanda, partner of HKA, Mr. Matthew Phiên, Senior Managing Director of Ancura, and Dr. Colin Ong KC, Senior Partner of Dr. Colin Ong Legal Services. And Miss Ngô Quỳnh Anh, the Managing Partner of EP Legal, will be the moderator. Thank you. I'm sorry, and I'd like to invite Mr. Cho Sin Yu. Excuse my pronunciation, sorry. Partner of Long in Partnership will be the moderator.
Thank you.
Sorry.
A very good afternoon to everyone. It's my privilege to be able to moderate the next session. Perhaps what I will do is to introduce the speakers, And so this is a session where you will hear from specialists and experts in the industry, and they will provide an insider's view and perspective on various legal issues. A very diverse list, I must say, and I'm very pleased to be able to introduce a very specialist panel. Perhaps if I can introduce right on the extreme, my right, Miss Anningo. So she's the managing partner of EP Legal. As you know, EP Legal is the sponsor of this session. So thank you very much, EP Legal. Annie is a commercial contract and legal expert, particularly in the Vietnam oil and gas sector. I think you have a long working experience, both as a legal practitioner and more importantly, in-house as well, in various energy companies. And you have been involved in various oil and gas projects in Vietnam. And I think in your previous life, you were at Unocal, PB Oil, Petro Vietnam. So, and I think you will be able to provide us with a very important insight on various specific Vietnam issues. Next to Annie is a gentleman I think who needs no introduction, Dr. Colin Ong Casey. Those of you who were here yesterday had delivered the keynote speech. I've had the pleasure of knowing Colin for many years. He is the first practitioner in ASEAN to have been appointed Queen's Counsel then, and of course now KC, a very prominent practitioner, not only in his home country in Brunei, but across Southeast Asia. He is called to the bar in Singapore. He's a very prominent arbitrator across many jurisdictions. And a staggering statistic, Colin has appeared as counsel and arbitrator in over 380 arbitrations. So a very impressive statistic. Next to Colin is Mr. Matthew Phiên, who's a senior managing director at Ancora, based in London, but with a lot of experience in work in Asia. Matthew, I think, is regularly appointed as expert witness in quantum, in energy, infrastructure, and construction matters. He's given evidence in UK litigation and in many high-value international arbitrations across the world. And in addition to his expert witness appointments, Matthew is a certified civil and commercial mediator, construction adjudicator, and also sits as an arbitrator as well. Next to Matthew is Shabila Nilakandan, who is a dual qualified lawyer in Malaysia and the United Kingdom, and with over 27 years of experience in legal contracts and commercial experience in the construction industry. She started her career as a construction lawyer in Malaysia before moving to the UK, and she's since undertaking various project consulting responsibilities and has over the last 17 years successfully acted for clients in the power generation and water desalination, oil and gas, rail infrastructure sectors in Europe, the Middle East, Africa, and Asia. And Shamila is an expert in managing complex claims. She had previously headed the Malaysian and Singapore country operations and now heads the construction claims and expert services for the APAC region with P&L responsibility for HK. Last but not least is a very good friend of mine, Ms. Mendelis, who is a partner in the Singapore office at King & Wood Mallesons. Amanda is a very experienced international arbitration counsel and also regularly sits as an arbitrator in various high-value commercial arbitrations across Asia. Very experienced, and I've had the pleasure of serving with her on the board of the Chartered Institute of Arbitrators branch in Singapore. And Amanda currently spearheads the CIOPS efforts in our teaching across Asia Pacific as well. So such a pleasure. And what we've done today is each of the panelists will spend a few minutes sharing his and her thoughts and giving you the insider views and their perspectives on various issues. After each panelist has delivered his or her comments and observations, I would invite the other panelists to add in any thoughts that they may have on the various issues. And perhaps if folks from the floor, if you have any comments, observations, or questions, please feel free to ask. Otherwise, at the end of every presentation, at the end of all the presentations, we hopefully with time, we will have some questions on the floor as well. So without further ado, may I first invite Colin, who will speak to you about various issues. I think Colin would like to share his thoughts on, the role of lead counsel in the effective management of complex energy disputes. I think he would want to focus on the dynamics of energy arbitration cases and also give you his thoughts on strategic considerations in relation to witness strategy, the use of experts, bifurcation, and also potential counterclaims in energy related. Colin?
Thank you, Sean. Good afternoon, everyone. So we all have a very limited time, 8 minutes each. So therefore, apologies, but I tend not to do slides anyway. First topic, multidisciplinary team of experts and the role of lead counsel. So the term multidisciplinary simply means that there's a gathering by lead counsel of a team of experts coming from different disciplines, because in energy disputes tend to be quite complex, whether it's upstream or downstream. And for example, for upstream, you might have geoseismic experts, you might have economists, and for downstream, you might have quantity surveyors, delay experts, and works. And the difficulty of a lot of clients is they do not really know how to pick experts. And sometimes, especially state-owned companies, they may go for the cheapest expert rather than the appropriate expert that may cost a bit more, but is worth every ounce of his weight in gold, especially where the quantum is of a very high value. So what is important is lead counsel needs to be able to figure out very quickly what type of expert is required. Now, sometimes the experts may overlap, especially those who are dealing in damages, and different experts may come up with different case theories, but you can only advance one. So it's critical for counsel to work and have a bit of mastery over whatever is the governing law of the contract. Because if you do not know the law of the contract, you wouldn't know how to present your claim for damages. And then sometimes leading experts, they tend to, they have a great set of skills, but sometimes there's a bit of ego. And as counsel, you have to manage this, and you need to have a bit of experience in dealing with this, because if you can't speak the same language as experts and offer constructive comments, you'll be in trouble. And experts from different companies tend to defend their position all the way down. Where they conflict, the lead counsel will need to make a strategic decision. Which expert do I go with? So that's quite important. I now quickly deal with the issue of dealing with state-owned enterprises in the energy industry. So having worked for most of the national oil and gas companies in ASEAN and a few more in North Asia, there are a few characteristics of state-owned companies. Number one, they're very bureaucratic. They tend to be large companies, employs a lot of people. There are many divisions. And sometimes it's quite difficult whether you're acting for them as a claimant or respondent. It's difficult for you to actually get the documentation because they're usually different departments, different divisions looking after different types of the project. It might be one EPC contract, but different divisions look after different aspects of it. So it's quite important to quickly educate all of the key players and to explain to them that time is of the essence in international arbitration, because usually state-owned companies are in danger of missing the deadline to file a response to appoint their party-appointed arbitrator to put in what is their defense, if any, and counterclaim, if any. And the issue of counterclaims is often troublesome when you're dealing with state-owned companies because they've been taken by surprise, they're scrambling, and they're trying to find out how do we deal with this request for arbitration. And then if you need to put an answer, that's the easy bit. If you want to put a counterclaim, then they need to know what are the counterclaims available. So not so easy, but lead counsel will need to be able to tease these out and quickly put together some heads of damages according to the governing law, and also a description of the type of counterclaim and an estimate of the quantum. And this needs to go in because later on your defense and counterclaim may fall outside your initial answer and counterclaim, for example. Now I move on to strategic considerations in dealing with other aspects of energy state-owned entities. So witnesses can be a nightmare because there's a whole host of personalities that you could call to be witnesses, and obviously they need to be there at that particular point in time when the event took place, leading on to a series of events and finally the dispute. So it's important to pick the right witnesses, sets of witnesses, and obviously you've got to make sure that the chain of causation is not broken, and you've got a witness covering the different areas and over the different time frames. And it's not necessarily the most knowledgeable witness or the person with the most technical knowledge, because some of these people, lovely people, but they just can't make up their minds when they're giving answers, and they come across as evasive or they come across as not telling the truth. So that's very important. With depth of experts, but it's also important to identify which expert to bring in first, because you need to plan your case strategy. And let me now quickly move on. The issue of bifurcation. Bifurcation simply means the splitting of the arbitration into separate phases. Bifurcation means two phases. It can mean separation of jurisdiction from the merits, or it could mean separation of the liability from the quantum phase. Sometimes in large cases, you have trifurcation. You have a jurisdiction phase, you have a merits phase, and a quantum phase. The objective of bifurcation is to try to get the parties to deal with issues which may dispose of the arbitration. Because usually, for example, if you have liability and one side's found liable, the side that's found liable is more compliant into making an offer to settle, and you may not need to spend a lot of money on both counsel and expert witnesses in the quantum phase. So the key of bifurcation is, number one, does it help to dispose of the issues in the arbitration? Number two, does it save costs in the arbitration? Number three, do issues of chain of causation matter? If that has to be considered in its entirety, then that's one tick against bifurcation. So these are the most important aspects that one needs to look at. And I think I might be within my 8 minutes now, so or just.
You're well within your 8 minutes, Colin.
Okay, thank you.
Maybe could I just it's interesting, Colin, that you you spoke about the strategic considerations in relation to appointing expert witnesses, but I'm actually keen to hear from two experts here, Matthew and Shamila, and in defense of your profession, do you have any views as to how would you sell the need to think about experts at which stage?
I'll have to go first if it's okay, Matthew. Yeah. Ladies first, as they say. I think appointment of experts has to be very strategical. And whilst there is legal strategy that will drive the dispute in terms of a tribunal or an arbitration or a litigation, the expert is there to provide an independent view. Now, I take Colin's point that you have to work with lawyers. Experts have to work with lawyers, but they have a remit. They have to remain independent. They owe a duty to the tribunal, not necessarily to the client, although the client's paying their fees. So there is a need to keep that independence, that remit, quite separate from the legalities of everything. We leave that with the lawyers. So I think that makes a good partnership. So there's no encroachment on each other. Timing-wise, of course, if you get the expert on board earlier, it's better. At HKA, we always recommend doing a preliminary assessment of the issue. So the client gets to understand, is this a go or is this a no-go? Shall we actually go all the way? And that way you are actually giving a commercial outlook, which is independent.
Yeah, I mean, I completely agree with most of that. I mean, the only point I would just raise is that in terms of being an expert, you inside the legal team, you're the only one that has a different obligation to everybody else, and that is back to the tribunal or to the court to be completely independent. And a High Court judge recently said to me when I was having this discussion with him about independence and what point do independence actually kick in for an expert, what the High Court judge was saying, well, even as an expert, when you're first appointed and you're doing a sniff test on a case and you're giving early recommendations or advice or you're giving preliminary opinions, that there is value in that, in the sense that because you're independent, your credibility and reputation is on the line as a credible international expert, that you give what you see as truly an independent view because it's your credibility on the line. And there's a lot of value in that. That value then means that can go into the case management. It can go into whether the case, whether the structure of the case needs to be and the strategy needs to be early settlement, or whether it needs to go into mediation, or whether there needs to be some sort of different form of pre-action protocol that needs to go through. So all of that is worth a lot of value to a client, particularly in a high value, high risk stake case.
Can I perhaps now ask Annie, and in reference to your very extensive in-house experience managing conventional energy projects in Vietnam, and obviously being involved in various disputes in the past, do you have any thoughts in relation to the use of experts? I mean, typically as the client, is this something that you will want to spend money on at a very early stage, or I just wonder whether you have any thoughts on this.
Okay, thank you, Mr. Chus. Actually, at the beginning, we got the feedback from the clients that their own people inside the system can be the expert. Why do I need to pay for the outside expert? And we got that problem at the very beginning. So as you all just listen to Dr. Colin about the use of lead counsel, it's very important for the big case in energy projects that we have the lead counsel and with a good strategy. And the strategy here is when we deal with the SOE governments, authorities, it's very difficult to persuade them to use of the expert. And in Vietnam, as you all know, that the expert is quite like new to our the whole system, in legal system of Vietnam. We don't know the use of expert before. So when we recommend for the experts witness, and we got the rejection from the clients at the beginning. And the good thing is with our lead counsel, we have the strategy to go. And why do we need the expert and how independent they are and why it cannot be the one inside the system. And the one inside the system just to be just the witness, factual witness only. We cannot be the independent expert. So we got the challenge, but the good thing as the lawyers that we try to persuade them and we give the big pictures to them and how the process will go with our independent expert. So luckily that later on our clients, they may listen to us, but some still rejects on that part.
So can I just add something? So what's quite important is that a lot of lawyers who may not be as experienced, they try to get the expert to say what they need the expert to say to help their case. That's the worst thing you can do, basically. So the role of counsel is simply to probe. So you throw a lot of darts at the expert and you watch basically, and basically if the expert realizes, right, I've got a weakness here, so the expert then knows, right, this is not the right approach. I might have to do it this way around instead. And you don't go further than that. You don't tell the expert, I want the end result to be as follows, because that's a recipe for disaster. And that actually happened in a recent case where I let Matt do whatever he wants, basically, but I probe him, and every now and then, and he eventually goes down the path that he wants to go down, and I said that's fine. The opposing experts on the other side, English experts as well, they got into trouble quite quickly in cross-examination after I was putting a few questions, and eventually they admitted that the statement was assisted by their lawyers, and after a while they just gave up, and then their lawyers started getting angry with their own experts and started cross-examining them in a hot tub. So that is what could go wrong, because if you try to make the expert go down a certain path, you can't fit a square peg into a round hole. And that, number one, is not the job of lawyers. And number two, that is not what the arbitration system is meant for. So it's very important to let the expert do his or her job properly, and you just probe to see if there are weaknesses in your expert report.
Thank you, Colin. I just wonder, maybe we just have time at this stage for one question from the floor. I see that there are a number of other experts in the room as well. Any comments or observations before we move on? Anyone? No? Okay. Otherwise, I would now like to invite Annie to share with us your perspective, particularly in relation to, as I said, your very extensive experience in working on energy projects in Vietnam.
Hi everyone, my name is Annie, managing partner of EP Legal. Some of you may not know me yet, but I was in-house counsel for quite 20 years in oil and gas sectors of Vietnam. I was working with the Petro Vietnam system for a long time and worked for Cửu Long JOC, one of the blocks offshore Vietnam, block 15.1. I was working with PVEP, the exploration and productions corporations, and also with Biển Đông POC. So I work in upstream business quite a certain period, and EP Legal, actually, we have the name at the beginning as exploration and productions. So it means that our partners, currently we have 3 partners, and we are from oil and gas system. And during the time we work with the oil and gas system, I work with the upstream business, midstream business, and after that I work with EP Legal for downstream business. And in terms of dispute resolution, we got the luck that we was working with one of the big case in thermal power plant, also with the hydropower plant in arbitrations proceeding. So for this conference, I would like to give the insider views and practical views on how the lawyers is working on the big projects and with the arbitration case. So as Mr. Lộc and also Mr. Trương Trọng Nghĩa already says, almost the energy projects in Vietnam are the national projects and belong to the state-owned companies. So that is very complex and highly require the difficulties in terms of technical and complexity. So each of the projects in energies are also no similarity. You cannot find like the same one in the like one project to the other. It's not the same. And I have to stress in here is on the technical part, which is which makes the energy projects is more like in difficult when we have the dispute. And some projects in Vietnam, it take long after like 10 or 15 years, and it still cannot be getting the COD, the commercial date. And it may be affected by the change in law of Vietnam. And also some projects related to the government warranties. At the beginning of the like original upstream business, for example, we have the government warranty for some offshore projects, but later on, there will not be any government warranty anymore, which makes the investor and almost all the energy projects in Vietnam, we have the foreign investors. So the foreign investor will have the difficulty when the government could not give the warranty to the projects anymore. And one of the most important things that I want to highlight in here is the dispute in the energy projects are highly factual and also highly technical. So you need to have the technical background, legal and lawyers. We need to know about the technicals of the projects. You go along with the EPC project, but you have to understand what is the equipment inside, what needs to be done, and then what is the like engineering about that. So the good thing for us, like as the lawyer, because we have the insight in-house for quite a long time, so we understand technical part of that, and it's very important when we solve the dispute for our clients. These are just some risks analyzed that we take during the course of the dispute, and we see some of the risks may highly affected to the EPC projects with the EPC contractors. And one of that is very important is a delay. Almost all the projects in Vietnam in energies is behind the schedules. And the delays come from a lot of like different issues. It can be from the investor side, it can be from the state-owned side, and also for the project implementation and the capabilities of both the contractors and the owners of the projects. So when the delay happens, you will get the dispute, and it will lead to the other cost of the actions, such as the financing. You cannot get the finance arrangement, and also the cost overrun. And when you know that the SOE projects, when you have the you have to resubmit the cost budget approval, it will be a long process. It takes years for you to get the approval for additional cost of the project. So we come to some common dispute that we may have in terms of the applicable law of the contracts. We like at the beginning, when you sign the contracts with the contractors, you may not consider this as much as you need to be care when you have the dispute. Then when you have the dispute, it may raise the question of applicable law of the contract. And as I talk about the behind the schedule, the delay, and issue over the force majeure event, in currently system, we have some case related to the sanction issues. So whether sanction could be the force majeure event or not, it will be like classified and it will be the arguments. And we need a lot of expert in terms of like sanction expert. We need to involve into that. We cannot define by ourselves, and that should be one of the issues that will be raised in arbitration. And the quality of the work. Now for the EPC contract, at the beginning, we have the engineering designs and we have the procurement and then construction work. But sometimes the contractors, they focus too much on the procurement work. They don't care about the engineering, or after procurement, then we have the final engineering. So the mismatch in the EPC process makes the project progress is not in the real situation. The project can be just only like 40 or 50% complete, but based on the procurement progress, it can be 70%. For example, like that. So when we go to arbitrations, the question is, what is the actual cost, or what is the actual completion percentage of the projects had been done, and how is the cost to complete? If you want to complete the projects, how do you like progress with that, and then what kind of like money, how much money you may need for the project to restart, or it can stay still for long after the arbitrations. So this cost to complete is touched on the expert determinations on the quantum here. And during the contract implementation, the contractors may be behind the schedule. They may like claims on the SOE, on the owners, that they are the one who makes the delays on the projects in terms of approval of things, and then claim for the termination. So whether the termination is the right one or the wrong one, who is the fault? And in the energy projects of Vietnam, normally we have the owners and the consortiums of the contractors, which the Vietnamese party will be the leaders of the consortium, and the foreign contractors will be like the consortiums of the contractors, or vice versa. So who will be the fault when one party claim for the others? Whether it's the same, the joint liabilities, or just the sole liabilities, it will be the issues in arbitration as well. And now we come to the point I did touch before. The Vietnamese party in our country is not well trained in arbitration proceeding. We are now like preparing the course, or like a lot of conference like this for the clients to start to understand on the proceeding of arbitration. But Vietnam also, we don't want to pay more. So why do we need the expert, like we just said? And also for the witness, the factual witness, who will be the right factual witness? We have to be very careful on this one. At the beginning, maybe 20 of them. Okay, I can do this job, and I can like list down all the thing what happened to the projects. But later on, when they come to the state near the hearings, they feel afraid, they feel responsibilities, so they want to like quit, or they want to take out. So we as the lawyers, we need like very careful in selecting the right witness. And one important is expert. They may not understand Vietnamese culture as well. So it makes the difficulties for the proceedings in arbitration. This is my last slide. Thank you for the timekeeper. And in this kind of like energy projects, we really need a good strategy, as our lead counsel, Mr. Dr. Colinong has said, and we really need the more effective use of expert in arbitration. And for the case management, you have to be well prepared for and get the case management in order to form up the proceedings, and to follow all the timelines and requirements for the productions of documents, for all the things during the course of arbitrations. This is some insider overview. Thank you so much. I think my time is over.
Thank you very much, Annie. May I just ask you one question? You mentioned that delay appears to be the most common problem in projects in Vietnam. From your perspective, and I suppose, as I said, you've extensive experience in-house, and you're now in practice. Are there any specific or unique features about Vietnamese projects, which you think I'm looking from the perspective of mitigation, in relation to delay. Is there any advice or insider tips that you can give to the audience?
That's a hard question for me. Actually, related to the project's progress, the owners, we do have the like management of the progress, where we put like percentage of the engineering or that the procurement process and construction work into that to make the overall like monthly progress report. So as the owners of the projects, we do have the controlling on the percentage of complete. But the problem here is the project management team, they may not so well like thinking about the management of such kind of like progress report every month like this, because they think that they are the owner and the EPC is a lump sum project. So they just need like the final project transfer to them. So sometimes they allow the tolerance to the EPC contractors to maybe you late on this one, we remind you, but then you have to like do it like on time or in progress for us, but they don't have the penalties to that. So that leads to the sequence of that, like for like few months and then few years, it may become the problem.
So it's essentially a accrual issue. Okay.
Yeah.
Thank you. Any comments from the panel?
Thanks, Annie, for that. I tend to work a lot with owners and developers and IPPs. We find that progress reporting is a tool that is very useful if it's honest reporting. I say that because contractors sometimes do not want to display any critical delay until it's quite clear it's due to an event they can pass on to somebody else, either the employer or for some other reason. So every month when I'm looking at programs and progress reports that my client receives from the contractor and then reports upwards the off-taker, there's always that challenge, whether there's honest reporting. And so, you talk about mitigation. If there's no honest reporting, how can we then mitigate the delay? So that's one concern to think about.
I think we should move on in the interest of time. And may I now invite Amanda? So she will talk about energy disputes arising from market volatility and energy transition. And I think you will touch on investor state disputes as well. Thank you, Amanda.
Thank you. And thank you. It's very nice to be here this afternoon. I'm just going to touch on a couple of issues to do with some of the macro issues which are happening and affecting the energy landscape. Firstly, in terms of climate change and energy transition. And in this way, I'll be referring back to some of the discussion we had in the first session this afternoon about investment treaties. And then secondly, the war between Russia and the Ukraine and the effect that's had on energy prices and how that has led to disputes. I'm going to have to go through fairly quickly. But first of all, I think some of the issues that Annie just highlighted to do with energy projects show why investment treaties have been invoked so often when it in relation to energy disputes. In fact, the biggest sphere of disputes between investors and governments actually relate to the energy sector. And that's because as Annie was talking, I made some notes. The things you can see in column 3, those risks are particularly apt when it comes to energy projects, given their complexity, the amount of time and the amount of money they take, and the involvement of governments. The fact that there's the sovereign risks in relation to the change of law and potential changes in the political landscape, projects that were in favour and no longer in favour. And you saw that a few years ago in Malaysia when there was a change of government and some projects were cancelled. And also the fact that there's a lot of licensing and approval processes involved with energy projects, all of which is the potential for things to go wrong. And the thing about investment treaties is they protect the investments made by investors from one state into another state. They give you rights under international law. They're not rights under the rights above and beyond from the national law in that particular country we're investing in. And the very, very powerful thing about them is it allows the investor to directly claim against the host state, and it's resolved by neutral international arbitration rather than state courts. And that can be through exit, through ad hoc arbitration under the UNCITRAL rules, many times administered by the PCA, who you heard from earlier, or institutional arbitration, such as with the ICC and SEC. And so very useful in terms of mitigating these types of risks with energy projects. So I'm not going to go through these, but just to, Vietnam has 62 bilateral investment treaties, of which 49 are in force, and is a party to 26 treaties with investment provisions. And they're treaties like the ASEAN Comprehensive Investment Agreement, and the Comprehensive and Progressive Agreement for a Trans-Pacific Partnership Agreement. We have to thank Canada for this mouthful when we could have just had TPP, but you know, we've ended up with CBTPP, which no one can ever say. It's become like a riddle. So there's 26 of these sorts of treaties that Vietnam's party to, of which 20 are in force, including the CPTPP, all of which offer investor-state dispute settlement. So the sort of protections you have, and I'm not going to go through them all, include expropriation, which deals with things like nationalisation, seizure, and other unlawful takings of foreign-owned property, both direct and indirect. By indirect, it means things like, say, changes to the tax structure so that it completely takes away the value of your investment. And then the other one that's very powerful and used a lot is the fair and equitable treatment. And that's what Neil referred to from the PCA when he was talking about the right to regulate. That's where that often comes in, is as a defence against a claim for the breach of fair and equitable treatment standard. But basically, FET is about the protection of the basic expectations that were taken into account by the foreign investor when they made the investment, and a requirement that the host state maintain a transparent, stable, and predictable legal and regulatory environment for the investment, and that the host state refrain from treating the investor or its investments in a manner that is discriminatory, arbitrary, or unfair. Now, why are this energy transition, climate change, that has led to actually a lot of investor-state disputes, and in two areas. One is in relation to conventional power, where various countries have announced that they want to phase out. So either in the case of Netherlands, phasing out of coal, and that they made that announcement in 2019, that basically they were going to have a 10-year phase-out period for coal. And so there are a number of companies which brought claims against Netherlands as a result of that. One of those claims, the RWE claim, is currently suspended. The Uniper claim was withdrawn because Uniper actually had to be bailed out by the German government following the Russia-Ukraine war. So as a condition of that, they had to withdraw their claim against the Netherlands. You also have a claim against Germany when Germany announced that it was going to phase out nuclear energy, and that was settled for $1.4 billion plus some other payments as well. The other area in which we've seen a lot of claims is in relation to renewable projects. And this is because, a bit like Vietnam, a lot of countries in Europe brought in a lot of incentives for renewable projects. And I think Neil referred to a case in relation to Canada, again, where there are incentives in relation to renewable projects. And there's been more than 60 investment arbitration cases, considerably more, against a variety of countries, and in particular Spain. Spain has had 55 cases plus against them. They've actually, 24 awards have been against Spain, 6 awards for Spain. There's still a lot of cases that are still pending. And what happened was, in 2007, Spain introduced a new feed-in tariff regime, but it was just too successful. It was too generous. It had a fixed price per kilowatt hour, which was higher than the market price. And it also gave renewable projects a priority of dispatch. And there was a particular window in which you could invest and get these type of projects up. By 2009, already the incentives were costing the Spanish government $2.6 billion. They felt they couldn't afford to keep going. And so they changed the regime. The problem was, so they made a number of different changes to the regime, including in 2013, where they made major changes, which in fact have been described as destroying the value of the investments that investors had made back in 2007, because those changes actually affected existing projects. They weren't just about new projects, but about existing projects. And this is why there's been 24 tribunals so far who found against Spain, including like one of the cases involving ISA and infrastructure. It was over 128 million euros they were found against. So why is this relevant to Vietnam? Obviously, Vietnam's introduced a lot of incentives as well for renewable projects. There are many projects that had to achieve commercial operation by certain dates. Vietnam is party to a lot of treaties. Asian parties are becoming more likely to exercise their rights under these types of investment treaties. So already we've seen a claim against Vietnam under the ASEAN-China investment agreement. Similarly, actually some Cambodian parties have made a claim against China under that agreement. So we're starting to see Asian parties exercise their rights under these investment treaties. And so, you know, both investors into Vietnam should be aware of what treaty protections they have, and equally the government should be aware of the possible ramifications of changing these schemes in terms of those types of claims. Finally, just to mention about energy disputes due to the Russia-Ukraine war. This was a chart I found. Now, we had a lot of clients last year. As you can see how high the price got, the price for LNG. And we had a lot of clients who were buyers of LNG and were finding their sellers were basically using every excuse they could to not deliver the cargoes. Instead, they were selling them on the spot market instead of delivering them under their long-term sale agreements. In some cases, they could make so much money on the spot market that even if they were penalized for default under their agreement, they still came out ahead. So you saw a lot of advantages of this with shipments being missed and so forth. And there are other problems in terms of sanctions and obviously people trying to manage the exit from various projects. And so what has this meant? As I said, there's various disputes over these missed cargoes. This is leading to a lot of contract renegotiations and price reviews. And again, we're seeing Asian buyers actually being prepared to initiate price reviews. And there's also related price disputes in relation to coal, where there's similar volatility in the market last year. So I'll leave it at that.
Thank you, Amanda. Obviously, what Amanda has touched on would actually cover an entire session on their own. I just wonder, any comments from the panel? Otherwise, I'll be happy to invite Shamila to do your presentation. Any comments? Otherwise, Shamila will speak about risk management concepts, and I think with a view of dispute avoidance.
Thank you very much, Sean. Happy to be here. I'll make mine quite quick if I can have my slides up in the first instance. Thank you. So as you know, I'm not a lawyer, I was a lawyer. Then I went on to greener pastures to become a consultant. So my views are not going to be legalistic. First of all, you know, when you talk about risk, you need to ask yourself, what are the causative factors? So HKA, the company I work for, produces an annual report called Crux. And in its 5th edition, that was released last year, there were top 3 causes. That's failure to manage change. As you know, variations tend to happen. You can't run away from unexpected changes because you assume some risk in the beginning, and these risks may materialize during project execution. Secondly, there are issues with design defects and inadequacies. We heard Annie talk about technical difficulties with projects. And thirdly, of course, poor contract administration. So how do we get this top 3 causes? It was based on an analysis HK undertook out of all of the projects it worked on annual basis. And for last year, it was more than 1,600 projects across 100 countries for a capex of 1.56 billion. For today's purposes, you say these are the causes. So what are the causes and effects really? And it leads to contract, legal, commercial risks. And the 3 elements I want to focus today: time, because it's important, time is of the essence. Again, Annie talked about delays being a crucial issue with projects. Second, fitness for purpose. Very important. If you don't have a plant that's technically astute, it'll never last for the sustainable period of life that it was meant to be. And thirdly, some general industry concerns. So time is of the essence. It's really a contractual thing because most contracts tend to specify it expressly. And so what happens if a contract doesn't have an express term? Common law says you can still imply it, particularly if the contract stipulates milestones, end dates. What if you don't meet that end date? You have liquidated damages. So time is always going to be of the essence, whether you have it expressly stated in the contract or not. Now, as I said earlier, the primary cause for delays usually is variation. How do you manage variation, particularly in the context of fixed term, fixed lump sum contracts? You don't anticipate change. You expect to pay for this much at the end of a project, but variations do happen. And I think it's only right that in every contract you define it clearly. When is it acceptable to have additional time? When is it not acceptable to have additional time? Now, even if you do clearly set it out in provisions of a contract, you don't get time automatically because there's a change of scope. You also need to show there are critical delays that has impacted your program, it's eaten up your buffer. And that's where people like us at HKA, we do program analysis to identify the critical path analysis and the events that have actually impacted on the final completion date. Now, having said that, there are certain instances, contracts are quite strict. They don't actually provide for such an EOT provision, but yet there are some changes, or there is basis for a claim for an extension. Then the common law position is you might be able to argue time is at large because circumstances have changed so much that you're not expected to meet that milestone or final completion date. Now, this is why when you do draft contracts, lawyers will tell you the allocation of risk is very important. Person who can control and manage that risk should assume that risk. So it's very important to keep that in mind when you talk about time is of the essence. Now, one exception about EOTs or really time is about you've got provisions that talk to force majeure, you've got provisions that talk to change in law. We all came out of an epidemic, or pandemic rather, and you found that these provisions did allow for some EOT. But for force majeure, you didn't get costs, you only got time. So there are time and cost considerations. So some proper dispute management obligations is, have a proper mitigation program. Annie raised this just now with owners and developers. Make sure that the contract provides a relief when there is a basis for it. Make sure notices go out. If you're a contractor, make sure you provide notices in a timely manner. And progressive deduction of liquidated damages. Now, I know that's a controversial point. Tony spoke earlier this morning about liquidated damages. But I think, if you progressively deduct it at times, you can introduce that in the contract. It's incentives to recover any delays. Fit for purpose. Now, I consider this a legal risk. Obviously, there is a technical element to it, but it's still a legal standard. Fit for purpose means it's primarily a test which involves a warranty that ensures fit for purpose for the intended use. Now, it's a very strict obligation. And it doesn't exculpate a party from that obligation. To be clear, it's beyond the legal standard of using reasonable skill and care. And on certain occasions, it's not even insurable. So Recently, HKO represented a owner developer because they got a supplier that gave them casings of a turbine that cracked. The turbine blades broke, and so the CCGT plant is not working anymore. So we had technical experts went in, reviewed the root cause analysis report that was produced by the contractor, gave an independent view as to what's the actual cost of this turbine damage, and that together with the legal standard to determine whether it was in its original state fit for purpose. Now, obviously, there's unscheduled outages, which means loss of revenue for the off-taker. So, you want to avoid this when you're an owner or developer. So there's always need for proper reporting of defects. Make sure, again, timely notices are issued when there are defects. And, you talk about defects, don't forget, it's just not until for defects notification period. You've got latent defects. Latent defects carry through even after acceptance. And that's a legal test again. And it's very much, most countries, it's dictated by statute. You try to insure for contingencies, but sometimes you can't. But when you do have defects replacements, the warranty management of it, so you've got extend such warranties, it is very, very important. Finally, just to talk a little bit about general industry concerns, listening to Amanda just now, I mean, the greener you go, the better. What have we learned from the law in Ukraine and Russia? Fuel, gas, these sort of resource availabilities, very much not only dependent on supply and demand, but also external factors like political and economical situations. We've had cases where price escalation has been an issue, and often either the contract doesn't allow for it, or even if it does allow for it, the indices is not sufficient to cover the actual escalation. And I know in Vietnam, I think Article 420 talks about the opportunity, if such a change does happen to a large scale, to negotiate out of it or to terminate the contract completely. So I urge you to think about whether conventional energy is a sunset industry. Now, even if you want to go ahead with coal and CCGT, it's also very good to have an alternative sourcing, local sourcing of resources, adapt to some new technology. And, we talked about incentives in Vietnam for renewables. We've got funding for more greener energy options. So I think diversity of generation, including, a good, sizable green energy portfolio is very, very important. Last but not least, I wish you well today. Thank you.
Thank you, Shamila. And I think time being of the essence, I will invite Matthew to present now, saving the best for the last, obviously. So he will speak on perspective from being a quantum expert on what he perceives to be common issues on power projects in Vietnam and in Southeast Asia, and he will also speak to his views on the causes of this.
Great, thank you very much, Sean. So just like to say thank you very much to the organisers for inviting me to Vietnam to speak. I come to Vietnam so often these days that it does feel like a second home. This is the 7th time I've been here in the last year, and thank you very much to the organisers for all the hospitality and making me feel, as I always do in Vietnam, very welcome. So I'm going to just be giving an insider's view, and I'm going to be talking a little bit about my experiences within Vietnam, but I'm also going to be comparing some of that more internationally. Thank you, sorry. So hopefully this works, which is a video. I'm not sure whether this is good. I hope it's right. It does, right. So this video is about 15 seconds, and I'll explain a little bit more about what this is. So we, as a company, we undertake a great debate every single year. It's one of our flagship events where we invite leading experts in the industry. We invite high court judges, leading arbitrators, and our own experts to debate what we see as the thorny topics of that particular year. And this year we did the great energy debate. And this was what the team that debated what the current issues are globally around energy projects. This is what they came out with as the core issues. And if anybody comes to London, I've asked the team to save this by. It's going to be in our office. So I'll gladly show anybody this particular animation that's been done for us on a large piece of paper. And it fascinated all of the lawyers and barristers and KCs that came to our venue to see this event. So I thought this was a good way to try and start this discussion. So just in relation to the basic principles of a claim, and I'm not going to talk about legal concepts, even though I studied law, I never practiced as a lawyer, and I don't profess that I can. But really, a quantum expert is really associated around this element part of a construction claim, which is causation and loss. And I make a distinction around causation because I'd say that one of the areas that even when I used to appoint experts, when I used to work for contractors, that experts, particularly quantum experts, don't ever really seem to get a grasp of is causation. They seem to go straight to loss and valuing loss. And without causation going into what the breach and the duty and the obligation was that was breached, then really the loss can be whatever you count up the invoices as being. It doesn't necessarily mean that any of that was incurred due to the alleged breach. So I'm just going to talk through some, these are some basic claims that I've seen recently within energy projects. And I was just going to talk briefly through how some of these is related to some of the matters that I've recently been working on in Vietnam. Defects, which again can be caused by workmanship or design issues. This is quite common with off-site equipment, particularly in energy projects. We'll just give an example about turbine. That's very common in my experience of having equipment manufactured off-site. You do get defects, you do get issues. And again, we've also designed as well. In the UK, we had a large scale of projects of waste to energy. We invested heavily within waste to energy. And it's quite common knowledge that fueled massive amounts of disputes that are currently still going through our High Court now, many years later. And one of the main reasons why was because of the interface around design and the technology changing so rapidly that they couldn't keep up. Professional negligence claims, obviously quite common where you're employing consultants and those consultants are giving you a duty and then subsequently they fail, and they can happen through designers, through quantity surveying, through architects, etc. Variations. Variations is a very interesting concept in Vietnam because if it's a civil engineering project or classed as civils, then it falls down to the Ministry of Construction rates, which are then valued, which is very unique to Vietnam in Asia. In most other areas of Asia, they don't have these concepts and they don't have the management of rates to the extent that Vietnam does. And being a quantity surveyor, I must admit, it was very refreshing to see how this process works. And this process really works on where you're building within Vietnam and the process in the region. And it is then set through indices, and they use indices and they review these rates every single three months, every quarter, and they publish the rates. So if you're pouring concrete in Soc Tang, then you'll have a rate that you use that is defined and you'll know exactly when that rate is. And it will be different to what if you're building or pouring concrete in Can Tho. So again, they work regionally. So when it comes down to variations, it's very interesting because international contractors, particularly a lot within Asia, don't use these forms of measurement. It's not used to them. We used to use them in the UK where we used to have such things as called NEDO rates, which have been gone since the 90s, but we used to use them on public sector contracts and they were a big part of what we did as a quantity surveyor. But times have moved on, lump sum all risk came in, design and build, or some people call it design and dump onto EPC contractors. And that meant the variations then changed. Quantum Merier, again, we've heard about force majeure, about time at large. These sometimes can bring around quantum Merier claims. Again, they're quite common within Vietnam, particularly within more the civils, less so in the energy sector. Termination cases, again, very common within energy sector. We've seen a number of these in Vietnam, particularly tied to sanctions. And Annie was talking earlier about how some of the damages can be assessed there, how they can be very different. Things like notational final accounts, cost to completes, all those sort of type of claims start to come from a quantum perspective. I'm just going to quickly run through these because these are pretty, we've talked a lot about time. Time is definitely an issue and there's lots of different categories to time costs that can be incurred. So staff, escalation, etc. But disruption as well. And I'm going to just pick a little bit more up on this in a second. So I'm just going to quickly give some very brief overviews of some projects. None of these are in Vietnam. These are all outside of Vietnam, but I just wanted to do this really to show some sort of comparison of some of the energy projects we've seen. This is a $1.5 billion gas power station complex. There was large cost overruns, and this project we were involved in very early on. We gave a preliminary expert opinion, and it subsequently led to a settlement, and we continue to work for this EPC contractor, which is one of the largest ones in Southeast Asia, and we still continue to work with them, and we have done for the last 10 years. And that's really by giving early independent advice, as we were discussing earlier. This one here is a $2 billion wind farm project. This one suffered significant delays due to statutory approvals, due to licensing, and lots of other issues. One of the biggest claims that I worked on this project was a loss of profit and overhead claim. And the reason why it was very complicated was because it needed a quantity surveyor to set out what all the different elements of overheads and profit risk is when applying industry standard formulas and when assessing actual cost. So this one was a particularly difficult case, which led myself and my opposite number, who are quantity surveyors, to value these works. But this was a significant claim as well that was really largely caused due to regulatory and statutory issues. This one here has been going on for a long time. This is in South Africa. It's a 4,700 megawatt power station complex, two of them actually. About $17 billion currently in dispute. We've been working on this for quite a long time. And this has kept a lot of lawyers, particularly in London, very, very busy for a long period of time. I think on our side, we've had 28 lawyers on my instructing lawyer side on this project for probably nearly getting on for 10 years. And I'm just going to finish quickly with disruption. Now, the reason why I highlight disruption, and this is particularly important for Vietnam, is that one of the biggest issues that we find, particularly on infrastructure projects, is that the way that cost is managed and the way that the programs are managed is very different in Vietnam. In the UK, we're very used to Gantt schedules, we're very used to critical path analysis, which we just discussed a minute ago. In Vietnam, it tends to be what Annie was saying, which is where actually it tends to be rolled up based on cost and hours and accumulated up. It's very similar to what we call earned value analysis, but it's not quite earned value analysis. And what it means is that when cost overruns, immediately people think it's delay. Now, disruption isn't delay. And disruption can be, you can have a project that's disrupted that isn't even in delay. And this is quite common, particularly on oil and gas projects in Vietnam as well, where hours are monitored and they're not necessarily understood as to why the cost overruns is. And just finishing very briefly, I haven't got time to obviously go through the detail of this, but the SCL protocol, second edition, which we as a firm were quite heavily involved in putting together, deals with the different forms of delay analysis you use, but also deals with the different forms of disruption analysis you use. And these are different forms of disruption analysis and the strength around the different forms of disruption analysis that a quantum expert would do. So that was the end of my presentation. Thank you very much for your attention.
Thanks very much, Matthew. I think we have some time for questions from the floor. So can I, yes, I see a gentleman with his hands up. Could you pass him a microphone, please? Please introduce yourself before your question. Thank you.
Thank you. Hello, everybody. My name is Viet Anh. I'm managing partner of Anhisa Law Firm. We all know that the war between Ukraine and Russia makes the LNG price increase a lot. So in the last 2 years, we saw, as Amanda referred, that too many contract renegotiation. And Colin also referred to a case of bifurcation. It's quite interesting under the English law, US law, Singapore law, but in Vietnam, we have just the final award. We don't recognize the partial award. So I have a question for you, both Amanda and Colin. That in your practical experience, how many percent of the case in the second phase, that after you issue an order on the apportionment of liability, how many percent the case can be settled by party agreement, and how many percent you have to go ahead with the second phase on the issue the second order to resolve the dispute? Thank you very much.
Well, funny you should bring that up. Sean and I were against each other on a case that was bifurcated. And yes, after the liability was determined, our clients very sensibly settled. So it does often happen that liability is determined and then people will settle, but you can't guarantee it. And sometimes the issue, and I couldn't say that there's a particular percentage as well. And sometimes the issues of liability and quantum are so intertwined, it doesn't actually save you that much cost to bifurcate, and it just increases the cost and increases the time. So I think it is a really difficult decision for tribunals to make, and for courts to make for that reason as to whether or not to bifurcate or not. It's easy when the parties agree, as they did in that particular case that Sean and I had against each other, because the parties were agreeable to it. But when one party wants to bifurcate and the other doesn't, it's normally because one party sees some advantage in bifurcating that the other doesn't. And so it becomes quite difficult for tribunals to determine whether to allow the application.
I would agree with that. But the real question is, from whose point of view are you looking at, right? So if you're looking at a party that has it could be a genuine intention, and it says, look, we can save a lot of costs and time and get this over and done with if we bifurcate the issue. And I'll give you an example, issues of law. Issues of law are quite easy to bifurcate comparatively. But the other party may not want to do that, because the other party may want to delay the arbitration for as long as possible, because it knows it does not have a case, but it's trying to buy time, because then it can get some financing coming in later on to pay off and settle it. Or a party could say, I want to bifurcate, but it's not really a genuine reason to bifurcate, because that party wants to split it into as many phases as possible so that it can prolong the final hearing date. It keeps pushing it down the line. So, but generally, once the tribunal decides to hear the bifurcation, hears the bifurcation, and if it orders the bifurcation, and it depends on what type of issues are asked to be bifurcated. But if the tribunal makes a decision on certain things, such as, like I said earlier, liability, chances are the parties tend to settle. I can't give a percentage because it's case by case, but I would say a very high number. But I think you were asking about the sanctions issue. So it depends, because a party can only get out of sanctions if you can say, look, this is a force majeure event, for example, right? But it depends on which country and which governing law applies. So it's easier to do it if it's common law, because we look at it on the it's what's defined in the force majeure clause. But in Vietnam, obviously, it's much harder, because Article 1561 of the Civil Code 2015 says you got to go through all necessary and reasonable measures before you can prove you can get into force majeure. So it depends. And it's the same with like Indonesian law, because this is a civil code system where you need to look at the codes. So it depends which governing law.
Yeah. Thank you, Colin and Amata, so much. We just want to share with you all that in the position of the leading council, we totally agree. And we do hope that with the new arbitration law, we're now drafting a new arbitration law. When we recognize the partial awards, so WEEEK, we have many secretary and the manager of WEEEK here. They may soon amend the rule, the WEEEK rule, so that we can have also the bifurcation, and like the many other foreign arbitration like the SIMC or LMA, they have the procedure on bifurcation. For any case that the tribunal will decide on the apportionment liability first before we go to the second phase. It's save a lot of time and cost for everybody. And thank you very much. Thank you.
Thank you. I see a hand there, please.
Good afternoon, everyone. I'm Nopamat, partner from Tilikian Gibbin Bangkok. Nice to meet you all. I like to ask the question to Amanda and Annie. Regarding to the energy dispute, actually, I think it is maybe the time during the transition from the coal age to the renewable energy. So I think that I comparing to the situation in Thailand when the Thai government give the concession to the energy company, something like that, and usually there would be some kind of a dispute. Yet not only Vietnam, Thailand also have some delays, all the project delays. So we quite similar. Okay, so I asked that because in Thailand experience that most energy case usually it go to commercial arbitration, but right now it seems that there are increasing investment arbitration toward the state, and it seems very effective too, especially in Thailand. We have the case, several arbitration cases that government lost in the commercial arbitration. Then the investor change the strategy, even though the investor win the arbitration case, but it take long time, sometimes like 30 years, you still hold the award. But you cannot enforce the award, right? So I ask you that since recently we have the King case against Thailand, and then the case is seems settled. It's not quick, settle within 3 years, something like that. So I asked the experience from Vietnam that whether or not this could happen, that some of investors may consider the investment arbitration against Vietnam for the energy dispute, and also for the international arbitration perspective. I asked Amanda, what do you think about this trend? Thank you.
Thanks, Nopramat, and it's such a pleasure to see you in 3 dimensions. We've been on a number of webinars together, so it's so very nice to see you here this afternoon. Look, I think there's been an explosion in investment state disputes, and I think that will continue. And what I think is very interesting is over the last couple of years, you do see a real rise in Asian parties now starting these types of claims against governments, and they can be very effective. In fact, King & Wood Mallesons acted for the first successful claim against India, which was just an illustration of the type of case you talked about. It was for the white industries, where again there was enormous delays in enforcing a commercial arbitration award. It was dragging on and on and on. 10 years, it still hadn't actually been heard by the Supreme Court, and they brought a claim for denial of justice, for which they were successful. So I think there are some claims related to that, but I think there are more the traditional claims. That's not to say that states don't win, because states win probably as often, if not more, than investors do, because there are tricky issues around jurisdiction. I acted for Indonesia in an arbitration just a number of years ago. There was a claim brought by an Indian investor in relation to a coal project, and we're very successfully able to show for Indonesia that the problems came from their lack of due diligence, and they should have been very aware of the risks that there were in the country involved. And I'm sure these issues will come out if there are claims against Vietnam. Similar issues about, well, if you've done your due diligence, these were very well known risks in terms of investing in Vietnam. So I think I'm sure we're going to see more claims, and I think it's a very interesting space in Asia to watch over the next sort of 10 years.
Okay, thank you, Amanda. And thank you so much for the question. Actually, we are facing several cases related to the energy state and contractors dispute currently. And we see sometimes the contractors and the state, we try to settle first outside the arbitrations or dispute resolutions. The recent case that we have, the government actually settle with the contractors after 3 years or 4 years of discussions. Before that, in the last few, like I think 7 to 5 years from now, we have several cases related to the tax issues, which is a tax of the foreigners when they withdraw the offshore blocks, and then they want to transfer the shares outside of Vietnam. So the government in Vietnam want to like implement some tax like withdrawals from them. And at the beginning, they tried to settle and they couldn't settle, and they bring that to the arbitration internationally. But finally, for the case, they settled that, and the contractors they willing to pay for the amount of money. So the chance of like moving from the commercial arbitration to the investor state arbitration, I think it will be like the opportunities for the investors. And also it will take to the settlements resolutions in Vietnam, because it also affects the Vietnam government's like image. So it is new chance, and I see some investor now also related to some of the government guarantees. As I told you at the beginning, we tried to settle outside. Later on, the investor, if they couldn't get what they can be guaranteed by the government guarantee, then they may sue the authorities, the government authority for the investment. Yeah.
Thank you very much. I'm being continuously reminded that our time is up. So all good things must come to an end. So could you just join me to thank our panelists for this session?
Thank you so much. And I'd like to thank you so much for all the speakers and moderator of the session too. Thank you. I'd like to invite to go on stage. The moderator and the speakers of the Section 3 renewable energy project, solar, onshore and offshore wind power, waste to energy, biomass, foresee the risk and potential disputes. I'd like to invite Mr. Giando Zapia, from the board member of the Eurotram, Mr. Kazuhide Oya, partner of Nishimura Asahi, and Mr. Tigran, the director of accuracy. And the moderator of the session is Mr. Nguyễn Ngọc Minh, partner of Dũng and Associate. Thank you.
Thank you, everyone. Thank you, VIC and VBOC and the organizers for the opportunity for me to be the moderator today, and also for the opportunity for firm to be the sponsor of today's event. And thank you all of the speakers and panelists for joining us, for participating in today's discussions. And thank you to all of the audience for being with us today. So to start these sessions, I would like to tell a little bit of a personal story. Last week we had a long holiday, and I went to Quy Nhơn and Phú Yên, and on the way, I saw lots of solar farms. And last year I also went to the Highland, and I saw lots of wind farms. So those are some of the examples of renewables in Vietnam. And the question is, why renewable? So the answer, this very short answer, is that Vietnam is a developing country and we are developing very fast. So there's a huge need for energy. But Vietnam is also exposed to climate risk and has international commitments toward renewables. Fortunately, we have huge potential for renewables. And against that backdrop, I would like everyone to imagine, what if you are an investor and you see a lot of potential in Vietnam, so you decide to invest in a renewable project in Vietnam, like say a wind farm in the south of the country. So you finish your development phase, you have a very nice project vehicle company set up, and you sign all of the necessary agreements to get connected to the grid. and to end a PPA. So you move to the construction phase. Things looks rosy now, but then trouble start to creep up. First, you have some minor disputes with locals in terms of like site clearance or like in terms of the site, construction site. And then you have your EPC contractor having problems with logistics, with getting material or like equipment. And during the time, the government may be introducing new laws or legislations, and you have delays. The delays lead to a failure to meet the COD, and then your negotiated concessions, for example, like fit price, become gone, just gone. So you have to renegotiate with the government, but the talk is not going anywhere. And that means you have to look for dispute resolution. You have to come back to read your contract to see the dispute resolution forums, or maybe in some cases, extreme cases, you have to go to the treaties to find an appropriate ISDS regime. And that is an example of today's topic, which is about risk and disputes in renewables in Vietnam. And I would like to introduce a very diverse panel. First of all, next to me is Gian Domenico Zeppler. He's a member of Eurocham, and he's from G Energy, and which is one of the largest energy operator in the world, and generating clean energy from renewables. Then we have Kazuhide Oya from Nishimura and Asahi. He has like 10 years of experience in Vietnam, and he specializes in energy, infrastructure, oil and gas, joint venture, and M&A. Last, we have Tigran, who is a director from Accuracy, and he's an expert who has given evidence in arbitrations in ICC, SIC, and before many tribunals. So to begin, I will introduce Gian Domenico to give a presentation. Thank you.
Thank you, and thank you everybody for being today here and for the invitation. I will be very quick so that we can jump into the discussion, and I apologize in advance. I will need to leave at 5:20. Enel is the largest renewable energy producer in the world. We have more than 60 gigawatts of installed capacity. We were the first investor to go large scale in renewables. Okay, thank you. Not really. And being present in 30 countries, our legal department is very large. We have had probably one of the largest pace of international arbitration for renewable energy in all over the world. We have many jurisdictions where we operate, and the differences are staggering. That's why we are trying to standardize our approach. And naturally, we like arbitration. We like international arbitration, especially in countries where Enel is not yet a big established player. We prefer to recur to arbitration in order to settle. And in most cases, we are successful. Although rules are changing, sometimes local courts enforcement is not really easy. And I would bring it to the floor in order to discuss how to mitigate these risks in order to make arbitration even more appealing. In particular, we are looking at countries like India, where we have witnessed the impossibility to enforce international arbitration awards. So we have to work with local courts, or in Brazil, where it's possible to introduce new facts. So we have decided to don't do arbitration in Brazil anymore. And the difference between civil law and common law jurisdictions, certain things applying to the American rules of arbitration don't apply in European courts. So in this part of the world, in Asia, we are a relatively new player. We entered only in 2015. We already had some experiences, sometimes also some shortcomings, and not understanding the importance of collaborating with local courts, of requesting injunctions, freezing assets, and not being able to really be effective in our arbitration strategy. And in Vietnam, we are starting from a point where the evaluation of recurring to arbitration, especially in some of our contracts, not being in Vietnam the seat of the arbitration is problematic, because the costs involved of doing the arbitration in Singapore, for example, and whether it's worth taking that step to leverage a settlement. Some problems also regarding our commercial structures, where the obligations of our local partners is always involving also responsibility of land acquisition, which is possibly, by a broad interpretation, one of the exceptions that are within the jurisdiction of Vietnamese courts, for which international arbitration might be excluded. And we are still studying what are the risks involved and what is the scope of this rule. I think it's the Article 470 of the Civil Procedure Code. So as a foreign investor, we look at construction as one of the main risks involved in the process of our investment. And sometimes for the appointment of arbitrators, we are even recurring not to lawyers, but to engineers who have good understanding of construction, clearly with previous arbitration experience. So several topics that I touched here. I hope it's enough food for our next discussion. Thank you.
Yeah, actually, I also prepared the presentation, but already a lot of speaker, mentioned most of the topics. So I will, very quickly go through my presentation. Can you open the slide? Hello? Maybe. Okay. Yeah. This is my introduction, but I will skip this one. Actually, I have one case in Vietnam about the brownfield wind power project, and also in Taiwan, the offshore wind project. It was also the brownfield. And our law firm, we have 19 offices worldwide, and lawyers more than 800. And yeah, this is overview, but the first part is almost overlapping with other speakers. So I will very quickly go through the overview of the renewable energy. Actually, this is a trend, but most of the people already mentioned. So construction, supply chain disruption, price volatility. Yeah, those are the causes of the energy related disputes. And when we come to the emerging trend, the energy transition, and also the fossil fuel is now decommissioning. So that one is also one of the issue for the causes for the disputes, and another one supply chain disruption. But yeah, already discussed, so I'll skip this one. And when we talk about the renewable energy sector, I put the three key features, but it is just a kind of comparative view. The one is that, of course, the regulatory environment is quite important for the renewable energy sector, and another one is a new technology. Maybe this one is also applicable to other sector, but in the renewable energy sector, when we apply the new technology in specific environment, in specific location, and the specific condition, it may not work. So that one may be the unique feature for the renewable energy. And also the grid connection related issue or the land compensation. Yeah, same. On top of the other standard issues. And maybe the even renewable energy sector, the construction related disputes, the conventional reason is always dominating reason. And yeah, these are other factors, but yeah, I will skip this because maybe almost all mentioned in the other presentation. And maybe in Vietnam, the land clearance, it takes quite a long time. So it causes delays or something like that. Okay, the advantage of arbitration, maybe this one is also covered in other discussions, so I will skip this as well. And yeah, investor state dispute, yeah, this one also I skip. Okay, I talk a little bit about the risk management of the project. Yeah, in Vietnam, it is long been discussed that there is a kind of bankability concerning this. In Vietnam, the credit rating of Vietnam itself is not that high compared to other Southeast Asian countries, but there's no DGU from the Vietnam, so it was very difficult for the genuine sense of the project finance perspective, very difficult. And feed-in tariff PPA, it is government sets the template and very difficult to negotiation. So the such PPA template had these issues, but I will not go into detail. And yeah, another one is a very minor issue, so I skip this. Then as a result, whether the renewable energy project in Vietnam happen or not, yeah, it's happened a lot. And it's surged into the solar power project. So as you can see, under the PDP7, it was targeted 850 megawatt, but in the end, it says 8,700 megawatt, almost 10 times more. It surged into the solar power project. And why it was possible, because there is a high risk appetite investors. Of course, without the project financing, they still invest in these sectors, and sometimes it's a smaller scale inefficient project, but still it's possible without financing arrangement, something like that. So yeah, if it comes to the large scale project in the future, including offshore wind power project, yeah, of course, the project finance is inevitably necessary because zero is one more than other projects. So it's higher, more expensive on the more large projects. So project finance perspective is quite important. So we expect the well-organized PDPA and also the new mechanism for the renewable energy sector in Vietnam. Okay, this one, basically the similar, some actual cases, but I guess there's some cases already introduced, so maybe I can skip this one as well. And investor state dispute. Vietnam is also have a lot of international investment treaty agreement, but it's also covered by other presenters. So I will just mention about in the renewable sector, renewable energy sector, maybe not yet that many state dispute so far, but maybe increasing in the future. Okay, takeaways. I believe that the renewable energy project dispute will be increasing in Vietnam because a lot of successful renewable energy development investment from various countries. So of course, it inevitably bring a lot of disputes. And the second one is that appropriate risk allocation is that's all actually. So it's most important when we organize a project. Appropriately allocate the risk is most important. And others are just a repetition. So yeah, that's all from me. Thank you.
Thank you very much. So first, before we continue, I would like to say thank you to John Domenico for your time. And because he has another business, so he has to leave a little bit early. And thank you, Kazu, for your very concise presentations. And before we move on, I would like to ask you a question. So in your experience in Vietnam, what is the most troublesome issues that you have come across in terms of renewable?
Yeah, Actually, the many speakers already, pointed out the delay, the land compensation delay, the approval delay, also the PDP8 is delayed, so everything's delayed. So yeah, maybe time management is quite important. Yeah.
So, yes, so the takeaway is that everyone is looking toward PDP8 and some kind of clearer regimes for renewables in Vietnam. And maybe another question before we move on is like, this actually is very simple because we have been touching on like some general risk, also some unique risk in terms of renewable in Vietnam. But then again, the question I would like to ask is that what do you expect to be the most likely cause of disputes in like 1 or 2 years from now on?
It's very difficult to predict, but I guess that traditional construction related to dispute would be still dominant in the renewable energy sector as well. So nothing unique, but yeah, I guess as a matter of number and as a matter of amount, value, it will be dominant, I guess.
Yeah, thank you. So we are talking about renewable and also about risk and disputes in renewable. And one of the things that Kazuhide foresees is the construction disputes in the renewable energy sector. And that means we will have to deal a lot with technical issues, also technologies. And this is where you may see an expert coming in. And so that on that theme, I would like to invite Tikran to present.
Thank you. Thank you. So yeah, I'll probably try and be quick, and just as a valuation expert, we'll have to show you some charts and tables. So sincere apologies for that in advance. So maybe just to reinforce the points that have been already made before, one of the global drivers for renewable energy is the climate change goals, and one of them is the so-called 1.5 degrees Celsius pathway. So what does this target mean for the renewable energy globally? Is that, as you can see on the chart here, so in the recent years, renewable capacity additions were 295 gigawatts per year. Now, in order to reach the net zero by 2050, those need to almost quadruple. And the same thing goes for the required investment in the renewable energy generation, which need to goes up by 3 times almost, meaning that, if the world is serious about the climate change goals, then at some point we'll have to spend $1.4 trillion per year on renewable energy. Now, these charts also aim to put the same point forward that basically there's huge potential for renewable energy going forward. As you can see now, fossil fuels still dominate the electricity generation market with 62%, and renewables are not even at a third of the pie. Obviously, again, if we want to be net zero by 2050, we have to move to almost exclusively renewables, with 5% for nuclear and fossil remaining. Now, this was more of a global picture, but let's look a bit deeper into Vietnam. Again, International Renewable Agency, they estimated that basically as of 22, the total capacity is probably around 25 gigawatts. Now, as you can see from this table, the potential for renewable energy in Vietnam is basically unlocked, especially for the offshore wind sector, which, again, the agency estimates it could be 300 times more, potentially. So I think all in all, what these slides say is that more investment will come if the world is really serious about reaching the set climate change goal targets. Now, moving on a bit more to the, again, common project timeline for renewable projects. I think for many people in the room, there will be nothing new compared to major infrastructure cases. So you start from development, you do your feasibility study, you arrange all your contractors and everything. And more importantly, you try to secure finance and reach a financial close. Now then you move to construction, you basically start to construct your plant. This is probably the most capital intensive phase of the whole thing. And that's where, as you've heard from other presenters, I guess most of the disputes will come out. Once you've happily constructed your project, you are ready to generate your cash flows and sell power. You reach commercial operation date and you start generating. Now, why is this important? Is because the nature of risks and the project economics are very different between the three stages. Now, this chart is a good summary from the US Department of Energy as to the view as to how the unknowns and uncertainties in the project change over time and what is the capital at risk. Now, obviously, at the development stage, your project is basically starts with an idea. It's pretty much a greenfield where you've spent nothing yet. And all of the value is within the prospective cash flows that you hope to generate at some point. So at this stage, this is probably the most difficult point in time to assess any value of the project or any damages that might arise from the breaches, because wasted costs are close to nil and the whole of the value is prospective. When you move on to the financial clause and construction, obviously you start spending more capital. So wasted cost claims get bigger, but the unknowns don't necessarily reduce that much, because if you still have a long way to go before your COD, the broader energy market can change a lot. So expectation losses at this stage could still prove tricky. Now let's assume you finally reach your COD and you think, okay, well, that's where the prospect of cash flow generation is absolutely clear. Your unknowns are minimized. In theory, at least. But the thing about this, we've heard about cases for Spain and other European countries. It all depends on how your incentive work and how your tariff works. So if there are risks in the pricing and tariffication, then again, your future of the project could be at stake. Now, quickly on this, what complicates things even further is that you have so many stakeholders in these projects, from equity sponsors to lenders, operators, obviously EPC contractors, and so on. So I guess what you have to be really sure at your development phase is that interests need to be aligned and risk properly allocated. Because I think what you can often see is that you have all these complex project agreements, but when something happens, it's not clear who bears the risk. So you need to be very careful at drafting those at the beginning. Now, very quickly, in terms of types of disputes and expertise required, land rights, obviously, many people talked about those today, that's where, again, if the dispute arises, you might need a local law expert in Vietnam to assist you in this case. ESG, more probably on the E side, when you need to get your environmental approvals for the site. I'll probably spend a bit more time financing. So Kazu referred helpfully to project finance. I think that's where, because project financing generally is a complex multi-party and non-recourse debt, which is basically secured against the cash flows. So all sort of issues can arise from it, for example, in the terms of, well, how interest rates are set. Are they variable? Are they fixed? Are they including like any payment in kind or, cash sweep terms and so on? And probably most importantly, when you do project financing of renewable projects, the proportion of that becomes very high generally. And that's where your equity investors are potentially facing higher risk than in other projects, because even a minimal change in the economics can basically wipe out their value in the case. Construction, I think we talked a lot, but maybe one point to note that typically issues like delay, cost overruns and defects, yes, they are sort of historical losses in a sense, but they all might have implications on the future cash flows that the project generates. And I feel in many cases that's something that people omit and don't necessarily claim. Operation, again, let's assuming you are lucky and you reached your COD and you are starting, to sell power, generate cash flows. Again, the key question here is the tariff. So how is your tariff set? And in countries where they use so-called, reasonable return of and on capital, that's where a lot of issues arise. Okay, well, what are the allowed costs that I can recover? What if I had a cost overrun? How does the overrun split between me and the off-taker? And then moving on to returns, again, in countries like Australia, UK, or US, where conventional utilities are regulated by reference to comparable returns that other companies earn, it is relatively easy because you can get some cost of capital data. But let's say you are doing a new project with new technology in a new jurisdiction. What are the benchmarks you're going to use? What is the reasonable return for an offshore wind farm in Vietnam? What is the comparable? So I think to wrap up, 3 key messages. Clearly, there will be more investments, meaning more disputes. Knowing where you are in the timeline of your project matters because risks are different and the value of the project is different. Hence, there is a different magnitude of the claims you can make. Know your expert, meaning that basically for the type of issue and the point in time you are in, you just need to figure out what sort of expertise you need and I guess instruct properly. Thank you.
Thank you very much, Tikran. So just want to ask you a small question because now I think we all get the feeling that in renewable disputes, one small issue may have a cascading effect and lead to bigger issues. For example, in Vietnam, when you have a small dispute with the local on site, that can lead to delays in the constructions of the wind farm projects or something like that. And delays in construction of the wind farm project can then lead to a failure to meet the COD. And if you fail to meet the COD, then you run the risk of, being unable to connect to the grid, or maybe some of your negotiated concessions, like the feed price, just gone away. Yeah. So the question is, what are the implications of delays on the value, or maybe of the claims, or maybe of the future losses? And as an expert, could you share some of your experience or analysis on that?
Yes, well, I think delay, obviously there are contractual / legal issues, i.e. what are the penalties if you don't meet your COD. I think one issue that typically is omitted from the claims I see is that if you have a delay, people then move to quantum and they claim the historical quantum in a construction dispute. But what is missing from this, if you have a delay of say a number of years, clearly at the very least, there is a time value of money lost, right? So if you could have started your project, sold power 3 years earlier, then there's a time value element to it. And the thing is that in emerging markets, because of the higher cost of capital, this time value could actually be quite substantial. So if you're talking about a billion-size energy project, then a delay of 2 or 3 years can actually be like in tens of millions potentially. So I think that one is missing. And then another thing, but it depends on probably the way your tariff is structured. What if you miss your COD by a substantial amount of time? What if interest rates change in a way that your reasonable return becomes substantially lower, right, than you expected, and you've already incurred your EPC cost on the assumption that your return would be much higher. But again, like this is probably a question of a legal as to how your PPA is structured, because it could be a fixed tariff. But then again, if it's a fixed tariff, if you skip the window, then the question becomes, well, what is the review frequency of the tariff? So I think those are the key points.
Thank you very much. Kazu, do you have anything to add to that? Thank you. So Maybe now we can move on to the Q&A sessions, and I think I've seen some hand raised in the audience. So,
Hi, good afternoon, everyone. I'm Sini from Sharp and Jagger in Singapore. I'm just curious, probably from the perspectives of the two lawyers on the panel. Given that some of this, especially for the wind power projects, some of this, because there's an international financing element, some of these contracts are governed by Singapore law, and it will be SIAC arbitration. But then the subject matter is actually, well, in Vietnam, and a lot of the local laws and regulations would govern. Would you foresee there to be any legal difficulties or challenges in those types of disputes that will come up on the pipeline in the next, I don't know, 10, 15 years?
Do you want to take the question?
Do you mean that when we choose the Singapore law or the Singapore SIAC arbitration as a venue, or is it your question?
No, so the contract is already Singapore law and it's already SIAC arbitration. But given that the subject matter is in Vietnam, and there will be it will be governed by a lot of rules and regulations here as well. Will there be any legal difficulties or challenges when there is actually a dispute, and then it's subject to Singapore law, and then SIAC arbitration, probably seated in Singapore as well, which is very pro-arbitration, as you would know?
Yeah, I understand. Okay, so maybe the first session, this issue is already discussed, I guess. The one is that, if the asset, the SPC, have a land in Vietnam, it is a, exclusive jurisdiction subject to the Vietnamese local court. So if the party choose the SIAC, for example, as a venue of the dispute resolution, but in the case, in the end, when we enforce in Vietnam, the Vietnamese court may say that, hey, this is land-related dispute, and this one is, subject to the Vietnamese exclusive jurisdiction, so the SIAC arbitration cannot be enforced or something like that. But in the first session, maybe lawyer says that there is a kind of criticism about such kind of judgment. In the past, my understanding is that in the M&A case, the company has a land in Vietnam. In such case, the Vietnamese court said that, okay, this one is land-related dispute, so the Vietnam have an exclusive jurisdiction. But that one, there is some discussion. So I'm not in a position to good about, but that's one risk. And another one is that of course when you get the award in Singapore, it must be enforced in Vietnam. As you know very well, but in Vietnam, a lot of cases saying that it is in violation or contradict to the basic principle of Vietnamese law. Then the court will reject the enforcement in Vietnam. So that's the base two risks and any supplements.
Yeah, thank you very much. Actually, I'm a Vietnamese lawyer, so I'd like to share some of my views. And the answer to the question depends on what contract you're looking at. Maybe if you're looking at a land leasing contract, then you may have the issue about the exclusive jurisdiction of the Vietnamese court. And I understand that the VIC and VCCI is trying to have an amendment made into the land law, the draft land law of Vietnam, to have, I think, land dispute resolved in arbitration in Vietnam. So, but when we are talking about renewable projects, it will not just be that land lease agreement. It can also be about the construction contracts, or maybe a joint venture agreement, or many other things, maybe even an M&A contracts. And depending on the contract and the subject matter of the contract, you may have to analyze the questions of the choice of law and choice of forum differently. And although I agree that there's always a risk that some of the parties may be very creative in reading the law, because many parts of the law of Vietnam are still uncertain or maybe kind of like subject to interpretations. But I think the general answer that we need to see the contract first, and we need to analyze the case based on the specificities of it.
Let me add one thing. When we talk about the PPA with Electricity Vietnam, the government has a template for the PPA. And there is a dispute resolution clause already prepared, and it says that the firstly, they need to go to mediation hosted by ELAB. And then the ELAB will, give award. And if the party do not agree, then go to the local court. That's a template agreement. So it's very difficult to negotiate. So as he said that, when we talk about which contract, it may be different issue in Vietnam. Yeah.
So maybe, yeah, thank you. I see Miss Queen. Yeah, Miss Queen has a question. Yeah, someone can.
You mentioned previously that in the case where the delay cost, the investor missed the COD, it's very likely that the valuation methodology is something like time value for money or discounted cash flow, something like that. My question is related to other situation. I mean that when we apply the DCF method, normally the investor should be able to prove that there is some kind of the investment should be a going concern. However, normally when we do the energy project, the investor normally establish a totally new company. And in the case where there is no construction yet, so the investor only obtains some kind of very initial site clearance or something like that. How likely the DCF method can be applied, or should we, how likely the historical value will be applied? Thank you.
Well, I think you can still apply both. But obviously, as I mentioned in the chart, if you're very early days in the project and it's basically kind of almost an idea on a piece of paper, and you haven't spent anything, you haven't even started, discussing, then obviously, well, I guess one can go for a loss of opportunity claim. But then the issue is that you have to figure out, well, what is the likelihood of the whole thing actually starting ahead, right? And obviously, the more you move in, the more the idea becomes, fleshed out. Then the lower the risk, and the higher your DCF value would be. But I'm sure there are people in the room who know, like, the tribunals. I think for them, they have the same concern generally. So if it's like a pure idea, greenfield project, and you do a huge value from a discounted cash flow method, the question becomes, well, how do you account for the risk that the whole thing might not go ahead in the but-for scenario, right? But this is generally something that I think we as experts, fortunately, don't have to deal much, because it becomes a legal, factual question, I guess, for counsel, for the tribunals, for counsel to argue, tribunals to decide. But again, I think that's why the chart I show basically it clearly shows how the value goes up the deeper you go into the project.
Thank you.
Hope this answers the question.
I think we can. We still have some time for more questions from the audience. Yeah, I think so. If actually no one has any further question, then I think I'll close the session by maybe just only one question from me, actually. This is to Kazu, because actually I'm not a transaction lawyer. I'm more of a dispute lawyer. So when Kazu talked about the standard form PPA, and says something about the dispute having to go through mediation first and then go to the court if mediation is not successful. So I just want to explore more on this, because like a little bit, because this is more of a like negotiation problems. And in your experience, what is the usual pushback against the suggestion for arbitration in that kind of case?
Sorry, I maybe I have no answer about it. What is a popular or what is more? But yeah, it may work, of course. But from the foreign investor perspective, it is such mediation is hosted by a kind of a Vietnamese government. So from the foreign investor perspective, we are not sure whether it is really work or not. So yeah, I do not have a specific, the example about, this happened, but that's a concern, general concern from the investors. Yeah.
Maybe I think I would imagine that maybe one of the pushback because it's a form that is issued in in legislation, so people may be reluctant to change to renegotiate it. That may be one of the concerns. So I think to close up this session, I just like to draw some takes away. The first thing is that everyone is still very much in favor of arbitrations, but people are also looking for improvements in arbitration in Vietnam. And the second thing is that I think we are all here, we all agree that one of the main problems at the moment is a delay in the issuance of legislation and the issuance of a clearer regime about renewable. For example, everyone is talking about PDP Act, and the investors seem to really looking forward to it. So I think that should be one of the concerns that need to be addressed in the near future, so that we can have more investors coming into Vietnam and investing into the renewable sector. Thank you very much.
Thank you so much. Thank you for all the speakers and the moderator of session 3. And after the event focusing on energy projects, we're gonna have the C-up conversation right after, starting right now, emerging trends in international arbitration in Vietnam and the region by C-up chapter Vietnam. So we do have some tea and finger foods outside. Let's take maybe 3 minutes, and then we go back for the C-up chapter section. Thank you. And I'd like to take the chance for 1 minute for advertising, as the ADR WEEEK for will have a very big event on construction in Vietnam by the evening or by the afternoon of the 12 May in Hanoi. It's going to be a lot of big constructors in Vietnam like Delta, Hòa Bình Group. They're going to attend the construction event. I would like to have your participation there with us. Thank you so much.
Chân nó giờ qua dưỡng. Rồi.
Thì anh cần ly nước. Bỏ luôn đi em. Anh đem luôn.
Chị cứ ngồi lên thoải mái đi, đang chín quay trong người là để giữ vài cái. Xong đi chị. Chị cũng không ai nhắn nó là cái gì. Em lấy từ một tờ giấy nháp nha. Chị lấy của chị luôn. Chị luôn nhắn cho em. Hay lên tập 3 nữa. Em đang đây của trẻ. Anh đi đây rồi. Đi đây rồi.
Hello, gọi cho anh ạ. Chị Trinh đang rất trông chờ anh. Thì chị bảo là chờ anh ấy để sẽ này sẽ khai để sau.
Bao giờ điều đến quân đến thì anh không phải đi đâu. Anh đi này mà. Đây bao giờ đến thì xíu. Ok, chạy nói luôn để các anh
Okay, so ladies and gentlemen,
cái giờ này là vâng giờ này. Thế để em gọi anh Dũng vào xong rồi ba anh chị phần em gọi Dũng vào. Vì lại mọi người cũng về hết rồi. Bây giờ này nó rất là dở dang. Vâng. Với cả một ngày đó, bởi vì là người ta chỉ chiếu cái em sẽ
Can you see? Can you see? Can you see? Can you see? Can you see?
Sáu giờ đúng người ta mới bắt đầu, 6 giờ đúng người ta mới vô. Rồi bây giờ ok, bây giờ làm cái session đầu tiên trước là 30 phút.
Xin mời tất cả các anh chị chúng ta ổn định chỗ ngồi để chúng ta có thể bắt đầu luôn phiên tiếp theo của ngày hôm nay, ngày thứ hai, tuần lễ trọng tài Việt Nam 2023. Ladies and gentlemen, please be seated so that we can start with the last session of today.
Thank you very much for who remains with us today. The the organizers, can you please let Jonathan in the Zoom? So this is a very, very unique situations. Delay happen in construction and everything. So we Jonathan's the president's election 2024 of SIAP is online, and he said that he's willing to proceed if anyone want to listen to him. Okay, we have today the first for the sessions we have today is about the role of SIAP in addressing emerging issues arising in international arbitrations, the interview with SIAP president. And then after that, we have the panel discussion among Nicholas Turners and Alistair Henderson, Mr. Tùng Ngô, and Mr. Dũng, Nguyễn Mạnh Dũng. Okay. As a unique feature of international arbitration, parties have autonomy to choose their seat and forums. Therefore, it's inevitable for Vietnam practitioners to interact and work with and be recognized by their peers in different traditions. It's also important that Vietnamese international peers are fully updated the market trends and at the same page in terms of professional technicality and ethical expectation. That is the main theme of our SIAP conversation today, the emerging trend in international arbitrations and how SIAP see its role as an institute that houses the network, global network of ADR practitioners. Okay, the effective way to gain an update from international arbitration community and the peers recognitions is to be exposed to and to be part of the global network. In 2021, Vietnam officially joined the family of Charter Institute of Arbitrators known as SIAP, and I got an honor to be elected as the founding chairperson of Vietnam chapter, which is operated within East Asia branch. Many colleagues ask me, what is the meaning of Charter Institute? And I think this is, we have a chance today to put that question to the president-elect of SIAP for 2024. Before then, I would like to share with you his unique background. The organizer, can Jonathan appear? Okay. So, yeah. Can you turn on the Zoom? Can you turn on the Zoom? Oh, the host stop it. Can I ask you to wait on? They are working on that. Technology problem. Okay, can you just hold on there? Okay, thank you.
So we are here to support the gender equality. So please patient with us.
No, this is a technology issues that we are going to discuss as well.
Jung and I are very, very grateful that you stayed until the last minute. Actually, it's the dinner time, okay? But you're still here. And I make sure that, we're going to have a interesting conversation with you because you and I both been in practice in application for quite a long time. Hopefully we can share with you and answer your question. And we don't want to keep you for so long. And after, listening to Jonathan's session, and we're very happy to say you very briefly about, the arbitration trend in Vietnam and Q&A. And we're going to make sure that, the message of Jonathan today going to be conveyed to the legal committees via me and Jung, and he's going to be listening.
Thank you very much. Thank you very much for your support, and Tung. I'm much sure that Jonathan understand that. And also we will have also not only Jung and Tung, but Alistair Henderson and Nicholas is also on the queue to wait. But Jonathan still cannot get in.
We don't restrict okay.
Hello, Jonathan. Hello, Jonathan. Can you get on? Oh, they said the host stopped him. So you can. Okay, so while waiting for the, so you can still speak, right? Can you still speak? Can you just exist and come back again? Maybe you can exist and come back again.
Can you please ask him to turn on the cameras? Just simply turn on the cameras.
You need to make him a co-host. You need to make him a co-host.
Nguyên cái UK mình chỉ có một cái embassy bên đó thôi. Cái đó chắc chắn là sure rồi.
Sorry.
United Kingdom.
Hello. Can you hear me?
Yes.
Right. So the host has unmuted me. Why doesn't the host deal with my video as my camera as well?
Jonathan, could you
Yes.
please turn on the camera?
My camera is on. So just give me 1 second and I'll try another. Yeah,
maybe we can start. We can hear you. It's good enough. We can start. We can have. Let me briefly introduce you, and then we go on with the session.
Okay.
Okay. Jonathan is a human rights lawyer before he became a dispute lawyer, specialized in maritime and arbitrations. Jonathan has been appointed as a dispute counsel to the British government export credit agency for 30 years, dealing with disputes over the globe. Immediately before being elected as the CIAP president for 2024, Jonathan has been the chair of the board of the trustee, which is the body that oversees the standard and the policy of CIAP. Jonathan has first-hand knowledge of the recent reform of CIAP to be more relevant and helpful to its member. So, the first question I would like to convey to Jonathan is the meaning of the CIAP, the meaning of the name of CIAP Charter Institute, and the history of CIAP, and the impact of his royal status of CIAP missions and operations. Over to you, Jonathan. Can we hear you? Hello? Cường ơi Cường, em coi được sao?
Not mute.
Jonathan, you on mute. Please turn on your microphone and the camera. Okay. Hello? Can you hear me?
So maybe we can check with the audio. Wait for 1 minute.
We believe that Jonathan has some problem with his internet connection. So can we move on while waiting to Jonathan to reconnect?
Is Alistair there?
Okay. We can see.
Hello.
Mr. Henderson and Jonathan now.
I'll go away now.
Yep. Okay. So, Alistair.
Yes, Chen. Hi.
Hi. So maybe we just have a free flow discussion today. So I think that we start with the trends, emerging trends in the region first, and then we move on to the Vietnam landscape and the Vietnam emerging trend. So maybe you start first, Alistair, with the first question that we discussed.
Certainly, Chen, and thank you very much indeed, and hello to everybody in the room. I'm sorry I can't be with you in person. Chen, the first question that you asked us was what arbitrators should do when they find themselves in a situation where one party is actively trying to delay or disrupt the arbitration procedure. You asked about the ethical standards and the procedural responses that might be appropriate for arbitrators. It's a great question. It's a really important question. It's becoming more important all the time, and we don't have a great deal of time to discuss it. Of course, arbitrators need to ensure procedural fairness, but fairness does not mean that arbitrators need to give in to the demands of any party who is trying to delay or disrupt the procedure. Arbitrators can be, and I think they should be, firm in moving the arbitration forward. And this issue is not by any means at all unique to Vietnam and Vietnamese arbitration, but it's a feature of Vietnamese arbitration as much as in other countries. What can arbitrators do about that was the question that you asked me. And I want to share with you that the court in Singapore, the Court of Appeal in Singapore, which of course is the overseeing court for many Vietnamese-related arbitrations, has given some very important guidance in 2020 on this topic in a case called China Machine that I know quite a lot about, I must say. An arbitrator's decisions, said the court in Singapore, on procedural matters are not likely to be challenged and criticized if they fall within the range of what a reasonable, fair-minded arbitrator might do in similar circumstances. Let me put that the other way around. You will be only open to attack as an arbitrator if your decision on any procedural matter is not a decision that a reasonable and fair-minded arbitrator might have taken in the same circumstances. And that reinforces that arbitrators need to be reasonable, they need to be fair, but they have a range of possible decisions and they should be willing and ready in the face of disruptive behavior to insist that the case moves forward, provided, of course, that both parties have at least an opportunity to present their case, even if they choose not to use that opportunity for tactical reasons. And to give you an example that's come up in my practice, it's not uncommon for a party coming close to a hearing to suddenly say that there are reasons why they can't attend the hearing. Another appointment has come up, a witness is unavailable, counsel is unavailable, and so on. I do not believe that arbitrators in that situation must always adjourn a hearing to another date when all the parties are available. It may be appropriate to do so, but if the date has been fixed for a while, and if there is no very compelling reason to justify the request for a delay, then arbitrators should be willing to say, no, we're going ahead on the date that I appointed. If you're there, great. If you're not, I'm afraid that's the consequence of your own actions. And the point I'm trying to make is that arbitrators need to be confident and they need to be firm in discharging their own duty to ensure that proceedings move forward efficiently and effectively. And in the past, we've seen some arbitrators be concerned that if they do push the case forward, they'll be accused of unfairness. The Singapore court's decision says not. You will not be accused of unfairness, provided it was a reasonable decision or one of the range of reasonable decisions that could have been taken in that situation. There are a number of other aspects of this question of delay and obstruction, which we could talk about if we had more time. I'm going to very briefly mention two before I hand over to Nick Turner for a comment. Firstly, it's important to remember that arbitrators do have the power to take account of bad conduct, misconduct, when it comes to an award of costs. They can punish a party for misbehavior by reducing the costs that it receives or increasing the costs that it has to pay. And for example, in my own practice as an arbitrator, it is my usual practice at a very early stage in my procedural orders to state that the tribunal can and will, in appropriate cases, take account of party conduct when it comes to consider costs, so that neither party can claim to have been unaware of that risk if it does later choose to misbehave. The last thing I was going to say on this topic was to discuss whether arbitrators can sanction counsel, punish counsel, penalize counsel for misbehavior. And this I am much less comfortable with. I think it is doubtful whether tribunals actually have the right, the power, the jurisdiction to impose penalties on counsel as opposed to the parties. And even if you felt that they did have that power, I think for tribunals to start penalizing and sanctioning counsel risks creating significant challenges to the award in future on the basis of potential unfairness. It's a difficult question for us to discuss in detail now, but I would say that from my perspective, the arbitrator's response to misconduct is better expressed through determination to move the case forward and careful ensuring of fairness while they do so, and then if necessary, punishment through costs rather than sanctioning the parties. Chun, there's a lot more I could say if I had time, and I know you've got a lot of
you still have time actually, because Jonathan's cannot joining, so you can still have time to do it. But during my discussion with Jonathan, he mentioned that SIAP as the only institute that have the kind of discipline actions regarding the members' behavior, and
yes.
if he can join in now, if the organizers still can let him in now, he can talk about the discipline actions regarding to the procedure behavior that you mentioned.
It sounds as if he may not be there, Chun.
Okay.
But
okay, so you can continue. You can continue. We still have time before we can move on.
On that very point that you've raised, in case Jonathan is unable to join us later, the former president of the CIR, Singapore's Chief Justice Menon, gave a similar speech a few years ago, where he suggested that CIR should have this role of disciplining counsel in international arbitration. And he again suggested that CIR was uniquely well placed to do so because it's an international, highly respected organization with great expertise in the conduct of arbitrations. it's fair to say that that suggestion hasn't yet taken hold. And there are 2 points I think that are important to consider. One is CIR doesn't have any power to discipline council. It is not a regulatory organization as far as Vietnamese lawyers or Singapore lawyers or any other lawyers are concerned. For those of us who practice in international arbitration, CIR does not have the power to impose sanctions and penalties on us. So it would be necessary, I suppose, to provide for that somehow, either in law or through the applicable arbitration rules, which could be contentious. Secondly, I think it invites CIR to get into some very difficult discussions about what is culturally appropriate behavior in different places, what is the difference between disruption on the one hand and simply robust, fierce representation of your client on the other hand. There is nothing wrong with strong, fierce representation as long as it doesn't cross the boundary into deliberate disruption. But where that boundary is a very difficult question, which may vary in different parts of the world. And I foresee that CIR would have quite a complicated time trying to police that boundary, as opposed to national bars who maybe are better placed to judge what is acceptable conduct for lawyers from their own jurisdiction. Perhaps then what arbitrators should do is report the matter to the lawyer's bar of qualification for further disciplinary action. But that's, again, a controversial suggestion. John, I might pause at this point and see if Nick has comments to make on this.
Well, Jonathan, can you hear me now?
Oh, Jonathan, we can hear you.
Yeah.
Right.
Yes,
So
we can hear you.
I am so sorry, but I'm afraid that the problem has been at the host end in Vietnam, and they've just unmuted me. So thanks very much for your patience, everyone, and I do apologise. But this is a very interesting discussion, Alistair, and at the risk of contradicting you, I feel a bit embarrassed here.
You should do. You should do.
CIR does actually have, firstly, a code of conduct, which is binding on all members of CIR, and it does in fact have a disciplinary process, which again is binding on all members. And the code of conduct is in 2 parts. If I can refer to it, it's on the CIR website. And the code of conduct deals with the role of committee officers for CIR. On the one hand, if you are a committee officer, you must act without self-interest, you must not gain from your position, and you must be disinterested, if you like, and act with integrity. So that's if you are in a position of an officer of the CIR. It does go a little further in the second part of the code of conduct, which regulates the arbitrators themselves. And this provides that arbitrators, for example, must not act with conflict of interest. It means that they must not act in a way which is unbefitting and such like, and they must obviously be impartial and independent. So the code of conduct is reasonably comprehensive, and in fact it's under some review at the moment. The point about it is this, that there is a disciplinary process which can be invoked by CIR against a member who is in breach of the code of conduct. And this has been invoked on a number of occasions. And let me give you some examples. For example, there was a particular arbitrator who took over 2 years to render an award. And in that case, the arbitrator was admonished and fined and deselected from membership. The mismanagement of funds has given rise to disciplinary procedures. So there are these powers. We have a disciplinary process which is staffed by, I think it's a former judge from Australia, I believe, and a couple of KCs. It is not often that this is invoked, and it is not very well known, perhaps, Alistair, but it is important, and it is something which is binding on all the memberships. So if a member was to act in some way in breach of trust, they are at risk of being in, sort of breach of the rules. It does beg the question as to, for example, you're talking about guerrilla tactics and stuff like that. Does it affect counsel? I think that's the point you're making, is that it may be difficult to affect counsel in a case, but it's certainly binding on an arbitral tribunal that they must behave in a manner which is befitting of them. Very important. It goes to the ethics of members of the institution. So that's my comment at this stage, and happy for Nick or anybody else to comment.
Yeah, I'm happy just to chip in here. I don't have, I should say that I echo everything that Alice has mentioned about the due process and the paranoia around it. Similarly, in Hong Kong, there have been a few cases where the courts have been asked to consider the merits, the decisions, procedural decisions and processes made by a tribunal in relation to matters. And the courts have very much, as you would expect, for a jurisdiction like Hong Kong, being very much hands-off, very happy not to interfere where those decisions have been made within, I guess, the four corners of the law and the rules that were agreed by the parties. And in one very recent case this year, where the court was asked to dismiss, where the court dismissed an application to set aside, it pointed to the ordinance in Hong Kong, which only provides for a reasonable opportunity for a party to present their case, as opposed to what the model law envisages, and a full opportunity, and reinforce that point that parties cannot expect to have a full opportunity, cannot necessarily expect in the scenario that Alistair suggests, to seek to adjourn hearings simply because they late in the day decide that they don't necessarily want to attend. I hear what Jonathan's saying, and I've just quickly pulled up that code of conduct, and great to be pointed out. Just quickly looking through the rules there, I wonder whether in this process of due process, this issue of paranoia, due process paranoia, maybe conduct of the process might come under scrutiny. But I wonder, Jonathan, whether there have been situations where conduct of a tribunal has been considered in light of these other powers and laws and or rules.
Not by the Chartered Institute, but of course the guerrilla tactics of trying to delay things, is all too common. And I think that certainly when the pandemic hit, there was a lot of jurisprudence in various courts around the world as to whether it was appropriate to have a virtual hearing, for example, and whether people could say, well, look, I'm entitled to an oral hearing, a virtual hearing isn't quite the same. The majority of decisions that certainly I've come across in common law jurisdictions and in some civil law jurisdictions all suggest that the party must go on. And trying to use the excuse that it's a virtual hearing and it's not quite the same, this paranoia of due process as well. I think that I think most courts would frown at people using the excuse that it was a virtual arbitration rather than an oral hearing. I think, again, I'm sure this is the same in Hong Kong and Singapore, certainly in the UK. As I keep saying, it's the party must go on, the hearing must go on, and this idea of there being sort of procedural paranoia, I think we have to, resist that. And I think there is room for robustness on the part of tribunals to go ahead and not succumb to tactics which are intended to delay.
Excuse me. I think that while Jonathan's still here, in the past few days, many distinguished speakers emphasized the need to maintain the high level of competence of tribunal and practitioner, and also the preservance of the integrity of the process. So to meet the fast-paced development of practice in international arbitrations, the arbitration community finds that to achieve this, the diversity and inclusiveness is not only a slogan, but maybe the way, the tools to achieve to achieve the competence and the compositions of the tribunal is quite important. So maybe you can share with us the initiative from the institute to encourage the diversity.
Okay, yeah, well, Trine, this is very important. And diversity and inclusiveness is one of the fundamental issues in the strategy of the Chartered Institute. You can find the strategy again on the website, and you will see that one of the paramount considerations is that as an institute, it is committed to diversity and inclusiveness. But what I think is important when we talk about diversity and inclusiveness is that it's not just limited to gender. Of course, CIARB has promoted the issue of women's rights and gender equality in the process. For example, it supports women in arbitration. It holds a special session around the world on International Women's Day on March the 8th, and it's very much committed to the gender aspect. But I think there are other aspects to diversity that we shouldn't overlook, and that's race, religion, and what I call the socio-demographic aspect. And this is important from Vietnam's point of view. For example, I was talking to some lawyers and arbitrators yesterday in Central and Eastern Europe, from Hungary, from Kiev, and from Poland. And their criticism was that you find that too many arbitrators are selected from a number of common law jurisdictions, whether it be England, Australia, Singapore, or Hong Kong. And the point that they're making is that now, after 1989, the breakup of the Soviet Union, you have in Central and Eastern Europe a new generation of highly talented individuals who act as counsel and as arbitrators. And it's all about capacity building. They've had time to get the experience, and they too should be given a chance to be appointed as arbitrators, to become involved in the whole process. And I think this is important from the Vietnamese point of view. I think capacity building in Vietnam is important, and recognition should be given to the talent in Vietnam. And Vietnamese lawyers and arbitrators should be thought of when considering appointments on the tribunal. So it's a sort of bigger issue than just gender. It's more important than that, if you like, and it crosses the social, demographic and geographical lines as well. And as I say, it goes to the underlying ethics of what CIARB is all about. It's a diverse and inclusive organization.
Jonathan, I remember that you mentioned about the social, the promotion of the social, what it's called ESG, environmental social governance requirement, and you also mentioned the initiative of many members of CIARB, like Lucy Greenwood for green arbitrations. Yeah, and on that point, I would like to talk to turn to Nicholas. Nicholas, I understand that you know, climate change and the energy transition have caused the many type of dispute, and I would like you to share with us your view on that, because I believe that Vincent mentions is in partnership with Queen's Mary to have the survey on the energy dispute survey. Thank you.
Thank you very much, Trin. Yes, that is a very helpful cue into the survey that Vincent Masons and Queen Mary undertook last year, the results of which were published in a report early this year on the 21st of January. It was the first survey to look at specifically energy arbitration in the last 10 years. And the timing probably could not have been more apt, given what happened or what has been happening in the world, particularly energy supply over the last couple of years. The survey looked at drivers of disputes as well as the process to resolve those disputes, and tested whether international arbitration was still the preferred mechanism. Thankfully, and spoiler alert, it is, according to those who responded, and we feel that we had a representative sample from across the globe, 900 respondents, spread fairly evenly across Asia, Europe, good representation in the Americas, Middle East, and Africa. Now, I'm not going to go into all of the details of it. It's a fairly lengthy report in its own right. I can arrange through Trin to share a link to that, and also some articles which sort of focus in on some of the key areas. But it's not unsurprising that the results of the survey were very much driven by the geopolitical issues, the Russian-Ukraine conflict that has been happening now for almost 2 years, the impact of COVID, the inflationary pressures that have arisen more recently, the supply chain issues, and all of those and the combination of them all have certainly influenced the way the survey was responded to. Transition, certainly the impact of those geopolitical issues was key to thoughts around whether or not the energy transition would be maintain the pace that it had, certainly with drying up of gas out of Russia. Those Western and particularly European jurisdictions had to go looking elsewhere for their energy supply. And in some cases that has meant, one might say, go backwards and look to the fossil fuels that had been being used as the source of energy, which meant that the renewables projects weren't happening. And as a result, people didn't, or respondees didn't believe that the energy transition was going to be a big cause of disputes going forward. Rather, it would actually be the volatility of price of materials that would be one of the biggest causes of disputes. Having said that, you have to get into the granularity of the results because issues around price volatility seem to be certainly more significant in Europe than it was in Asia if you start to go down into the detail of it. Sanctions we looked at, and obviously there, for those that are caught by sanctions, and sanctions can impact in many ways, not simply, buying and selling materials into or from those sanctioned states, but also the impact, the knock-on impact on projects, and also on the supply chain issues around resources. That was looking at the causes, just quickly touching upon the process of arbitration, international arbitration, and its usefulness for energy disputes. It was basically, I gave away the punchline. Most respondees believed that international arbitration was going to continue to be the main source of resolving those kinds of disputes for many reasons, but not least because of its ability to cross borders. Interestingly, London obviously was, well, I say obviously, London maintained a top seat as the, top slot as the seat of choice. Interestingly, Singapore from Asia took second. And I say interestingly because Hong Kong, where there's a healthy competition between the two jurisdictions, was quite significantly lower down the ranking, possibly because of Singapore's historical being historically a center of for the region for energy related disputes, possibly also because of its connectivity into other parts of Asia, which Hong Kong hasn't historically been connected. Just touching upon the diversity and green arbitration points, because it's been mentioned and we picked up on those in the survey as notable features and where respondees ranked those. Unfortunately, Jonathan, as much as the hard work of many have been to push that agenda, when it came to the ranking of diversity, it was the second last in our survey as being the most important feature, and then greener arbitration was the last with almost no real interest. Now, I don't necessarily believe that is probably the true story. I think that there's probably more behind that. Certainly, when it came to green arbitration and in the interviews, I think there was a recognition that arbitration is changing. The process of arbitration is changing to make it greener. I think just when it really came down to it, and somebody was asked, would you sacrifice the service to ensure the product was greener, there was the hesitation there. And maybe there's some education, more education needed. And I think maybe just the process of getting more people on the bandwagon to realize what the real benefits are. And I'll leave it there. Maybe I can either pass on to Alistair. I think I'm sure he's got some observations from Singapore which would be valuable.
I do have a few. Let me start with environmental, social governance issues in arbitration. I mean, this is a huge topic in international arbitration at the moment. There's an awful lot that's being written about it. There are many conferences that are talking about this topic. And of course, there's some very important surveys being done, including by Pinson Masons, that environmental and social issues are giving rise to disputes. And that's right across right across the board, from the highest levels of international law, where, you know, for example, you see countries, Pacific nations, talking about possible claims, existential claims, because they're concerned that rising sea levels are actually going to eliminate their country as a political entity, and they're looking at legal recourse in that area. Right down to private sector claims, where you might see a business bring a business interruption claim against its insurers for transboundary haze or flooding in its factory, and seeking insurance cover for that. On a social level, we have experience as a firm, I have experience of a case where the issue in dispute in arbitration was the disruption to a supply chain, to a particular supply contract, because the Southeast Asian supplier had had its business shut down temporarily due to employing child labor in its factories. And that had come to the attention of certain international groups, which had prompted the local government authorities to close down that factory, and claims arose from that. So there is no doubt, those are just a few examples of how ESG matters are giving rise to disputes. It's not a novelty. These issues have been involved in disputes for some time, but it will become, I imagine, significantly more commonplace as time goes by and these issues rise yet further up the international agenda, because they are incredibly important and influential in terms of business. The conduct of arbitration, well, arbitration lawyers have been thinking quite carefully about what they can do to reduce the environmental impact of the arbitration process, most obviously by trying to control the paperwork involved and the travel involved, which are two of the very obvious ways in which arbitration can leave a very heavy carbon footprint. I'm seeing increasingly in arbitration, and again in my own practice as an arbitrator, a paragraph in early procedural orders telling parties that they need to be mindful of the need to avoid printing everything in multiple copies, the need to avoid wasting paper, more arbitrators being prepared to accept electronic bundles rather than hard copy bundles, and so forth. And more emphasis on virtual hearings, particularly for procedural matters, but also for merits hearings, to avoid the extensive and expensive carbon footprint of international travel. So I think both at a substantive level and a procedural level, ESG considerations are impacting arbitration, and undoubtedly they will continue to do so with ever increasing force. You also asked about, well, there was a discussion about diversity, and this is something I think is exceptionally important in Southeast Asia, including, but not only in Vietnam. There is a shortage of experienced international arbitrators from Southeast Asia countries. And I think the procedural fairness and the expectations of Southeast Asian users of arbitration demand that they should have access to an experienced, talented pool of international arbitrators. It's not that the talent isn't there. Let me be quite clear. There is a lot of talent in these markets, but it is not yet being recognized internationally. And international parties are not yet selecting arbitrators from Thailand and Vietnam and Indonesia in the same way that they might, for example, appoint an English person or an Australian or an American to a Southeast Asian dispute. And that seems to me wrong. And I think that the work that CIARB does and other organizations like the Singapore Institute of Arbitrators are really important here in building that capacity and in helping some of the many very talented arbitrators in this region to get greater exposure, greater recognition, and frankly, more appointments. I think it is really important that that should happen in order to ensure proper diversity and cultural representation in the process.
Thank you. Thank you very much, Alistair and Nicholas, for updating us the emerging trend in the regions. And now we would like to turn to Vietnam. And I would like to ask Dong, in your views, what are the emerging issues that need to be addressed in arbitration in Vietnam? Legislation amendments or quality of arbitration practitioner? The same question to you as well after this.
Thank you. Thank you. It's not a good time, but again, I very appreciate your staying with us until this last minute. Jonathan and Nicholas, Alistair, you said all what I want to say. Okay, thank you. Actually, the first point I want to say, I want to comment is the paranoid. My kids often call me, daddies, you are very paranoid. From the perspective of an arbitrators, we are arbitrators, and practicing lawyers, I often advise my lawyers, don't try to play tactics in arbitration, because during the arbitration process, it is a process of persuasion, not the process of playing game. Okay, so I see some cases in WEEEK that counsel of both sides, they play the game, but we hint to them, go to the point. Okay, make your clients defense fairly. Okay, that's the first point. The second point I want to comment about diversity. Okay, I don't want to insult gentlemen over here, but I realize women smarter, wiser than men, especially in legal practice. They can arbitrate better than men. The evidence is my wife arbitrate me fairly every day. Okay, and the second evidence, Chin is a good lawyers in the country. Right now, she moderate, 5 of us, 5 leading lawyers in Vietnam and the region. Okay, there's no issue of diversity in Vietnam, especially in the city, like Hanoi and Ho Chi Minh City. The roles of women, especially women lawyers, more and more important in the society. The next point I want to say about the landscape of legal practice and arbitration in Vietnam. I think it's a good time. That is the reason why many of you from Singapore and other countries coming to Vietnam. It's a good time for arbitration in Vietnam. Those we still have a lot of loopholes in arbitration in Vietnam. I'm going to say it very briefly. The first point is why arbitration in Vietnam is a good time. I share with you, in 2021, Vietnamese courts handles 16,000 cases approximately. Okay, and they can only handle probably 10,000 cases, and 6,000 cases still remain unsettled. This means that there's still a lot of room for businesses in terms of arbitration. Okay, and we have the legal framework in Vietnam for arbitration. WEEEK is the leading arbitration centers in Vietnam. Besides that, we still have 40 others, 43, okay, he got a number, 43 arbitration centers in Vietnam. And, Mr. Yung gonna comment on the operation and qualities of arbitration center in Vietnam later. But I say with you, it's a good time for arbitration because of the court system in Vietnam. Okay, the confidence of the business communities keep increasing in arbitration. But there is a lot of stuff we need to do in Vietnam to make Vietnam become arbitration friendly country. Okay, the point over here is, it take time, and lawyers, scholars, business communities, we need to do a lot to help Vietnam to be an arbitration friendly country for the sake of Vietnam. One of the point I want to say is setting aside domestic and foreign arbitral awards is an evidence that we are not yet there. Okay, we need to do a lot. So what we need to do? We need to do, the first one is, probably I think that in law school, we need to have, arbitration, course, training the new qualities arbitrators for Vietnam. And for the legal committees, we need to do a lot, not against Vietnamese court, not against a complaint Vietnamese judge, but work with them. We need to have more, conferences like this. And I wish to see just to be here, to coordinate with us, to understand why we do so, why arbitration help Vietnam to improve FDI, improve business environment. Okay. But, I share with you good news. We did a lot. We have done a lot. And so far we are here today. Hard work paid off. And I see a pricing, a promising futures for arbitrators, especially one of my colleagues over here, Mr. Yung. He worked, I believe, at least 60%, 70% his time for arbitration education, for the next generation, for, legal framework improvement in Vietnam. So I believe with the effort of not only Mr. Yung and many Vietnamese colleagues over here, and with the support of, foreign experts like you guys, Vietnam gonna be a good playground for arbitration activities. Thank you.
I can't agree more with Tung on the needs to have the conversation. But before anh Dũng start, can I just have a quick introduction with Tung? If anyone who doesn't know him, I don't believe anyone who doesn't know him. But I just want one thing. Tung is the key figure to bring VLAF and the transition between Clifford Chan to VLAF, and you know why he's a good speaker.
Just help me to convey the message to my wife. Okay, he arbitrates me fairly every day. Thank you.
Thank you.
Thank you, Mr. Tung. I echo what Mr. Tung just says. So I don't think we really have any problem with diversity in Vietnam. For example, in my firm, small size boutique shipping ADR law firm, we have total 6 partners, and 4 of them are women, 2 are men. And in our arbitration team, we have 4 key partners, and 3 of them are women. So they work very effectively. So we would not worry about that, right? So on the other thing, I just said a little bit about this. And Mr. Tung just says our domestic arbitration is getting closer to international arbitration practice. Several years ago, in our VIC arbitration process, we don't have the concept of the CMC, PO1, timetable, conflict of interest, evidence. Now we adopt all of that into VIC arbitration process. So for our local arbitration colleagues here, almost of you working in the domestic arbitration because 90% of the cases are domestic cases, only 10% are international. But I still have to learn international arbitration practice because now you have to use that in domestic arbitration. That's one thing. We have also adopted IBA guideline on international on conflict of interest in international arbitration in the VIC template for statement of arbitrator on independent and impartiality. And now VIC is preparing to adopt the IBA rule on taking of evidence into their own rule. So we play the same thing like we can play in SIC, HKIC, or ICC. The second thing is my personal observation is that now people not only try to find out what's the difference between the arbitration and the court system. Due to the arising infrastructure construction dispute, there's more demand on specialized arbitration lawyer, right? So you see that there's a need to find out what's the difference between the construction arbitration and energy arbitration and investment arbitration. Now we have to learn not only about international arbitration, commercial arbitration. You have to learn more than that, right? You have to find out what's the difference when you act for the client in construction dispute or in other field of law, because construction sector is now rising rank number 2 after international trade. It's the most popular type of the dispute handled by VIC. The last thing is, as an impact of the Singapore Mediation Convention, now the client, our enterprise, end user, do not just need the ending of the problem by the arbitration award. They need their problem being solved. They need their dispute is settled properly, right? So if you go to arbitration, don't think that you just need to use the arbitration skill, because VIC strongly recommend all the tribunal under their rule to recommend the party option of amicable negotiation or mediation at the CMC from the beginning of the case. And if the party agree to negotiate or to mediate, your role is more than the arbitration lawyer. You become the mediation lawyer to advise the client what you should do in the mediation process. And you should know that the fundamental differences between the arbitration and mediation process is huge, right? So that's only 3 things. I think that's an emerging trend in the domestic arbitration. And I'm sure that with the rising number of the case, and Mr. Tung just said, we have every year about 16,000 cases involving foreign party or not in the dispute and commercial dispute. There's more room for 44 arbitration institutions in Vietnam to work, and also more room for international arbitrator and international arbitration institution come to Vietnam market. So that's all the thing I can share with you today, and thank you very much.
You know, I wish we could stay here for a few more hours to talk. We love to talk, but you know, time is limited. So we open the floor for 1 or 2 questions, especially with the, you know, Nicholas, last time Jonathan over there. We don't want to keep them stay for long on the screen. Any question?
Amanda, please.
Yeah, I'll ask a question only because we were talking at the beginning of this session. There was a discussion about ethics and particularly about the behavior of counsel and sanctions. And one of the things that the LCIA brought in was a code of conduct, which was in the rules, and no other institution has adopted that. And I didn't know whether perhaps Jonathan or being based in London knew how effective the code of conduct in the LCIA rules has been seen as being something to, you know, manage the behavior of counsel and reduce guerrilla tactics, and why it hasn't been picked up by other institutions.
Thank you, Amanda. I got a message from Jonathan that he need to leave already for another lecture. So I will pass that to. But Alistair can make comment on that.
Well, I do know the answer to that actually, and I'm only slightly hesitant because I don't want to take the words away from a colleague who's going to be addressing this at an event in Singapore tomorrow night. But the headline point is that the LCIA has introduced this power into its rules, the code of conduct and the power, and it has so far not been very extensively used. And I'm not sure whether there's been any adverse findings, even if matters have been referred to the tribunal. But I don't have the data, the exact statistics to my fingertips. But I think it's been used rarely, if at all, although it is there in the rules.
Just a minute, for your own information, like any international arbitration institution, VIC also have their own ethical rule. And we also go further by adopting the same approach at the court, that we have the hearing rule. And lastly, maybe I share with our local colleagues here that VIC arbitration practice shows that the tribunal tend to tend to sanction the counsel of the party if they try to cause a delay to the arbitration process or to disrupt the arbitration proceeding by allocating the legal cost at the end of the case. So you should know about that. There is sanction to the counsel of the party. Yes, quick.
I mean, there are a number of Jonathan rightly reminded me that CIRB has its own code of conduct for CIRB members. SIRB in Singapore has produced a code of conduct also for counsel in arbitration. And most bar associations have general codes of conduct for lawyers. One of the difficulties that I foresee in trying to have a really meaningful international and enforceable code of conduct for lawyers with sanctions applying is that there are legitimate differences in approach in different parts of the world. There are some parts of the world where lawyers are expected and do regularly just take every procedural point they can possibly find and expect that if they make 90 challenges, one of them might succeed. And that's not considered to be bad behavior. That's just the way that litigation and by extension arbitration is conducted in some parts of the world. Whereas in another part of the world, exactly that same behavior might be considered to be outrageous and disruptive. So I think this is an area where we need to be careful about drawing international normative conclusions about what is and isn't acceptable. I'm not saying it isn't possible. And at the extreme, I think we could all agree what is extreme and disruptive behavior. But I'm not sure we can agree a comprehensive code that covers everything without recognizing that there will have to be differences from country to country, potentially.
I have a question about evidence. If in the case it is obvious and manifestly clear that an evidence is falsified and provided by one of the party, is there any mechanism to prevent that? And is there any mechanism to sanction the lawyer who submit that evidence? Because normally, if a normal lawyer should always see that the evidence is falsified. It doesn't require any technical like analysis about that. Thank you very much. And my question is for both SIAP and VIAC.
So, Alistair or Nicholas, do you want to comment on the questions? You go first.
Well, I can. The answer is that in most international arbitration rules, and forgive me, I don't know about VIAC rules, but I expect this also applies. It is stated that the tribunal has discretion to decide what weight to give to evidence, what evidence to consider and admit into the case, that it is entirely for the tribunal to decide what evidence it will find persuasive and weighty in its decision. So if a tribunal considers that a particular document has been forged or a particular witness is clearly lying, it is entirely acceptable for the tribunal to decide that it is not going to place any weight on that evidence, essentially to ignore it. Now, most tribunals would not simply say, I'm not considering that evidence at all. They would say, I've considered the evidence, I've concluded that it is unreliable, that it is, a forgery or perjury from a witness, and therefore I've chosen not to place any weight on it. That would be completely acceptable if that was a valid view of the evidence. As to whether the tribunal could then penalize counsel, that goes back to the question that we're talking about, which is, does the tribunal even have the power to do so? And if it does, should it do so? Should it report the lawyer to that lawyer's home bar? Should it penalize the party in costs? These are difficult questions, and I'm not sure that there is yet a consensus in international practice as to the answer to that.
From WEEEK perspective, I cannot answer on behalf of WEEEK, but I can answer on the capacities of an arbitrators of WEEEK. The first thing is the fundamental of arbitration is the autonomies of the parties to defend and freedom of choice. And during the arbitration, the counsels of the party, they have the right to challenge. And if they don't challenge, I don't think that the arbitrators and the tribunal is the one who raised the issues for them. And on behalf of any parties. So knowledge counsel, that's the responsibility of the counsel to point out the roles of the arbitrators is to give the freedom for the party to defend, to argue their point. So that is my views.
Just due to the legal consequences of the case Vincent Sung Hing at the court of Hanoi, the VIC Arbitration Tribunal very reluctant to say clearly in the arbitration award that they rely on the IBA rule on taking of evidence. That is first thing. The second thing is the tribunal, almost tribunal will not declare in the arbitration award why they sanction lawyer of the party because of the independent impartiality. Because they worry that the losing party may submit that award to the court and say that they are not independent, they're not impartial, right? So I can say that the Article 68 of the Law on Commercial Arbitration, paragraph 2, on the fake evidence and independent and impartiality of the arbitrator, which we borrow from the Chinese arbitration law into our system, got a lot of the risk for the tribunal, arbitration tribunal in Vietnam. So we not clearly indicate in the arbitration award why this evidence should not be accepted or considered by the tribunal, or why this particular counsel be sanctioned by the arbitration tribunal in the arbitration award. But there is.
Thank you. Thank you very much for being patient with us. Thank you. Oh, you want another question? Yeah.
Okay, so just the last question. Thank you so much for all of your sharing. I have a question for both Vietnamese and non-Vietnamese speakers. So Mr. Dũng already mentioned mediation, right? So and we can see the trends. The Singapore Convention on mediation is very topical right now. So my question I would like to hear from your perspective that do you think that Singapore Convention will receive as much as success as the New York Convention has received? And do you think that, not all, like the UK talks about the New York Convention, Vietnam talk about convention, the Singapore Convention, but do you think that the government will do anything about that or just keep talking, right? Do you think that there will be any changes in the landscape of our court dispute resolution with the rise of mediation? And especially, Singapore government has been trying to promote mediation in the convention a lot. All right, thank you.
I just heard that UK recently joined Singapore Mediation Convention. So they not just talk, right? But I agree with you, Vietnam talk too much, right? Yeah. But as I just said, even we haven't joined the Singapore Mediation Convention. But the two important things we note that first thing, Supreme People Court has already got the court enact mediation law, right? They know how it's important for mediation to reduce the caseload at the court. So they know how it's impact. For Vietnam, also the mediation community really want or try to encourage the authority to join the Singapore Mediation Convention as soon as possible. But it's not belong to us, it's belong to the authority. And they have more priorities than just Singapore Mediation Convention. But it doesn't matter. The important thing is that both two active mediation center in Vietnam is VMC, Vietnam Mediation Center belong to the VIC, and VICMC are encouraging to use mediation, right? And even at VIC, I just explained to you that the VIC also recommend on the user try to settle the case by mediation, not wait until the final award to be rendered. So we are not just talk, we act quickly.
Yes, I acknowledge that. I know that you guys even have more discounts, like VMC more discount if you change the package and things like that. Yes, but I mean in the government, things like besides Decree 22, right? We actually do not have any changes. And it's not my question. It's just like a lot of scholars are wondering right now about the Singapore Convention. Everyone talks about that, but is it going to be just a short-term trend, or how is it going to change the landscape of dispute resolution? That's what we are curious about.
Yeah, I agree with you. We all very excited to see if there is a new law adopting the Singapore Mediation Convention. As our last Zoran meeting of VBDC, remember in Dallas, we proposed to our Mr. Đỗ Ngọc Thịnh, the president of the Law Society of Vietnam, that if no one submit any proposal to issue the new law on commercial mediation adopting Singapore Mediation Convention, perhaps Vietnamese Law Society, the Mr. Đỗ Ngọc Thịnh as a National Assembly member, should propose to the National Assembly that Vietnamese Law Society are willing to draft that law for the state authority. I'm not sure that its idea will be executed quickly as we expected, but Tung can add.
I want to respond to your questions. The first one, don't be pessimistic. Vietnamese is fast learner, okay? The second comment is don't just wait. Do something, work together, make something happen. So I believe that that's what we have been doing. So, and I believe in bright futures. Even you can see a lot of obstacle, paranoia in the process of lawmaking in Vietnam, but basically it's happened.
I thank you so much for being with us until this time. It's a message emphasize so many times that we need to have conversation. We need to have the more training to increase the competency. To wrap up this, I'd like to share with you one good news about SIAP. SIAP Vietnam chapter really wants to grow the community, and the good news I'd like to share with you is we have organized with the EAB support. We have organized the first ever accelerated route to membership. And we have a very, very encouraging number of candidates, good quality candidates. We have around 25 candidates. 10 of them are partners from professional law firms, and 4 of them are arbitrators. arbitrators and professors. And most of them are young associates who are very keen to learn and very keen to observe and fast learner. Thank you so much. Thank you, Alistair, and thank you, Nicholas.
Thank
for
you,
being with us.
Alastair,
Yeah.
Nicholas, and special thank to you guys. Wonderful.
Thank you so much for the audience. You must be very hungry.
Thank you.
And thank you for allowing me to join you. It's been a great pleasure. I wish I was there in person.
Thank you. Good night.